There you go. And also, we will be asking everyone to ask questions through the Q&A button at the top, at the bottom of your screen. Just push the button. You can ask questions to the various speakers, and myself or Chris will help guide the questions as time permits. There will also be a 30-minute break for lunch and a 15-minute break later on for a quick coffee. So thank you again. And Chris, I will pass it back to you.
Thanks very much, Hirsch. Just thought I'd take a few minutes to provide a little bit of context for what we're trying to do today. You'll notice something that's a little different. We've called on Ontario directly, the government, to open the law and let the people decide. And the law we want them to open, of course, is the law that maintains a monopoly on the delivery of legal services by lawyers. And at the outset, I want to say that I want to thank all those who over the years, over the decades, who've worked so hard to deliver justice to Ontarians, Canadians, and those around the world. The judges, the lawyers, and the other justice participants who've dedicated their lives, who have given a free service, who've given of their money, who've developed different ideas to provide justice. But we are where we are. And where we are is not where we need to be. And in spite of all the great efforts and hard work and determination, justice in Ontario serves about 2 out of every 10 people. 1 out of every 10 businesses. It's about the same across Canada, and in your jurisdiction, you may have similar figures. Those aren't my numbers. You'll find them in the Access Report of 2013, spearheaded by then Chief Justice McLaughlin and Justice Cromwell. You'll find them from the Law Society report. You'll find them from people and reports and studies throughout the world. The fact of the matter is that access is not improving. It's actually getting worse over the years. It is affecting huge numbers of people who at one time might have been able to afford legal services, but now can't. It's affecting huge numbers of businesses who need the resolution of issues in business time, not legal system time. It's affecting families. It's time to change the approach. It's time to change the conversation. We appreciate and thank all those who speak about the issue. Today, we're going to hear from people who have been doing something about the issue. The speech is good. The work is better. The speech is important, but a speech without action is not helpful. And too many of the speeches focus on us as professionals. You know, the one that includes more judges, more lawyers, more money, more stuff, all of which is fine, but it hasn't delivered the access that people want, that people need, that people have a right to. And let's change the conversation so we're not talking about access to justice anymore. It's a right to justice, a right that the overwhelming majority of people and businesses are not getting. They're not getting. They have a right to it. The focus needs to be on those people and businesses, not on the professionals. And what do they ask for? They don't ask for more judges and more lawyers and more courthouses. Their universal complaint about the justice approach, the approach to resolving their issues and problems, the approach to just understanding how they go about obtaining the resolution it is their right to obtain. Their universal complaint has been that the approach designed by professionals is too complex, too slow, and too expensive. At its heart, that has not been addressed. It's time to change the conversation and focus on the user, the consumer, person, the business. Their lives are being affected. It's the woman who cannot get out of a situation of danger, has to remain in a relationship. She can't find the route out, can't afford the route out. or the family that's stuck in a family proceeding for years that is inherently confrontational when there's a better way. It's the small business owner that needs the resolution of a human resource or a contract or a reorganization or a hiring issue. Can't afford, can't get the answer from law that they have a right to. It's time to change the approach and change the conversation. And we're going to hear today from speakers who have been changing the approach, who've stepped out, who've taken the next step. You know, in the pandemic, a government reached out to others who are not involved in healthcare to say, we need help providing some equipment, personal protective equipment. We need help doing these other things because there was a health crisis, and it worked. And people stepped up. We've had a justice crisis for decades. It's time to let other voices in. We've had a justice crisis for decades. It's time to let others help. It's time to open the law and let others participate. You cannot maintain a legal monopoly that serves a tiny minority of people and businesses. It's hurting the people, it's hurting the businesses, it's hurting Ontario's economy. You can't build a 21st century, hard driving, innovative economy on a 20th century legal platform. We need an economy that supports innovation and jobs. And another characteristic of the pandemic is that we want decisions based on evidence. Evidence, not myth. Wear your mask, evidence, not myth. And yet we have a rule that seems to have existed forever that says lawyers can't work with people who aren't lawyers in delivering those legal services in an ownership interest. Why is that? Why can't non-lawyers, as they're called, work with lawyers in a business, in an ownership participation situation? But we're told that it would damage the lawyer's ethics. There is no evidence for that. None. And if you want to look somewhere to show there's no evidence, the Law Society of Ontario accepts about 6,000 members who work in corporations delivering legal services to the corporation. No, it won't damage your ethics to rub shoulders with the rest of the world. We're not superior. We know our ethics. We're not going to dissolve. It's time to let others share their expertise with us as we deliver legal services. The business model created, the legal service delivery model created by the existing rules and structures and monopoly serves 1 out of 10 businesses, 2 out of 10 people. That's not a good business model. And for those lawyers out there who are newer to the profession, who are looking forward to achieving what you wanted to do when you became a lawyer, helping the people you wanted to help, you need all the tools possible, all the expertise possible. You want to serve all the people possible, the missing 9 businesses and 8 people. Those are your potential consumers. You want to be able to reach them, and the existing rules and structures are not reaching. It's time to change the conversation and take a different approach, just like a different approach has been taken with technology. You know, that we are the profession which has said you can't do things with technology. It has to be in person. It has to be by pen. It has to be in a courtroom. 5 years ago, Hirsch and I wrote about how Zoom could help. Web conferencing could help. Audio conferencing could help. Oh, never. Well, it is. Well, it is. How quickly things change. Let's base it on evidence. Let's open up the law. And I say to the Ontario government, it's your law that maintains the monopoly. It's your law that maintains the restrictions. It's your law that inhibits economic activity, inhibits job growth, hurts small business, hurts people, does not deliver justice to all the people. You didn't create this problem. No, not a chance. You didn't create it. but you can do something about it. We need the government of Ontario to help out here. Now, I'm looking forward to our speakers today, as you are, and I'll have a few words to say at the end. And Hirsch, why don't you introduce our first speaker?
Thanks, Chris. Okay, thank you. It is my great honor to introduce Justice Himonas, who was appointed to the Utah Supreme Court in 2015. For the decade prior, he served as a district court judge where he was able to try hundreds of criminal, civil, and family law cases and run a felony drug court. In addition to his judicial duties, Justice Himonas has served as an adjunct professor at the University of Utah Law School and has spoken nationally and internationally on legal issues, including with us earlier this summer. He is a recipient of the Judicial Excellence Award from the Utah State Bar and a Life Fellow of the American Bar Foundation. Justice Himonas graduated with distinct from the University of Utah with a bachelor's degree in economics and went on to receive his JD from the University of Chicago. His goals in life include creating the perfect Negroni, embarrassing his grown children, and annoying his wife of 30 plus years. We have a lot in common. And he says 2 down and 1 to go. He also chairs 2 access to justice task forces, I believe one on online dispute resolution, which is a favorite topic of ours, and co-chairs a 3rd, which is reimagining the regulation of the practice of law. It is a great honor to have Justice Himonas here today, and I will pass it on to him.
Good morning. What a pleasure to be here. I only wish that I was there in person with you all, and hopefully, this time next year we're able to break bread together. Before I start talking, I want to set one ground rule, and that is I really don't want a lecture. I want a conversation, and I would encourage questions throughout. And Hirsch or Chris, if one of you would be so kind as to curate those questions and just interrupt as they pop up, that would be terrific. So I see my role this morning breaking down into 2 pieces. The first is to kind of make the case for reimagining the regulation of the practice of law. And the second, to talk to you about some of the things that we're doing in Utah to take on the access to justice issues, the crisis that's been pervading not just the United States, but the world, really. So with that, next slide, please. We talk about the access to justice crisis, and I want to give you some data. I think probably most of you are aware of it, but to the extent you're not, I think it might be helpful in terms of setting the table for why we're doing what we're doing. Your next speaker, Gillian Hadfield, Professor Hadfield, had published a book called Rules for a Flat World. And in the book, Professor Hadfield identifies that almost half of the world's population, about 4 billion people, live outside the rule of law. Unable to, within our civil system, access and take advantage of the rules that many of us take for granted. And that's a problem that is not, just visited upon third world countries. If you'd go to the next slide. In the United States, right, we see that this is the result of the most recent World Justice Project Rule of Law Index ranking. We are almost dead last when it comes to access and affordability of civil justice. So for those of you that don't know, the World Justice Project each year since 2011 has been conducting a massive study, about 130,000 households each year and 3,000 to 4,000 legal experts to come up with their rankings. And they rank legal systems along a large number of metrics. But I want to focus on 2. One is access and affordability of civil justice, and the other is bias in racism in the system. So as you can see, for the US, we are, as I say, almost dead last when it comes globally, and we are dead last amongst the wealthy nations of the world. Next slide. It's also true in Utah. For my fellow Utahns, right? We think that maybe it's different here. Indeed not. an in-depth recent study conducted by the Utah Foundation showed that, similar to what Chris was reporting, about 82% of the civil legal needs of low-income Utahns here were unmet last year. Right? And it doesn't really drop based on income the way that you would think. California found that at 6 times, at 600% of the federal poverty guidelines, right? 78% of the legal needs were still being unmet. Next slide. Right. The problem is not just about access and affordability, but there's also a question of discrimination within the civil justice system. Here, the United States falls to 115th out of 128 countries globally when it comes to the civil justice system. And again, next slide. You know, this is true in my state as well. What we can see is a high number of minorities, ethnic populations in the lower income populations that are predominantly heavily affected by, I should say, by the access to justice gap. Go ahead, next slide. All right. The second thing, so aside from the access to justice problem is we have to ask ourselves, what are the implications of that? Well, certainly one has been a massive shift to unrepresented parties in our court system. I think it was based on 2014 data and a study of 1 million cases across the United States. The National Center for State Courts found that in roughly 75% of all cases, one or both parties was unrepresented. In Utah, we looked in the major metropolitan area at all adult courts, so excluded juvenile court, but looked at all civil cases in the adult court, small claims as well as in district court. In 93% of the cases, one or both parties was unrepresented, right? And we understand why, right? The law is lawyers are expensive, or people don't trust lawyers. Or some cases, it just doesn't make sense to go to a lawyer. So again, the National Center for State Courts found that in roughly 75% of all civil judgments were worth $5,200 less. So even if we did have the means, even if we did want to hire a lawyer, it made no economic sense to employ counsel in those cases, right, under the current structure. Next slide. Oh, what have we in Utah done about it? I want to talk about very briefly about 4 things that we've done and really focus on the last one today, obviously, reimagining the practice of law. Before I do, though, let me pause and see if there are any questions at this time in terms of, as I say, setting the table or making the case for regulatory reform.
Justice, there's one question about what young lawyers can do, but that might make sense to answer near the end. But there was a question around what can young lawyers do to ease the burden of access to justice? And
well, I really want to take them as they pop up, and
great.
So it's a great question that I hear a lot of, and it really it heartens me, because I mean I've suspected that the next generation is more attuned to these issues, and at least anecdotally, you know, through these conversations that's certainly been the case. And what I would tell them is be active, have your voice heard, right? If you're going to hear from me in a second. The reason that in Utah we've been able to do some of the things we've been able to do is because of leadership from the bar. Be that leadership, right? Support these efforts. Recognize that we can never volunteer ourselves across this gap. I really want to echo Chris's comments that, you know, lawyers have been spectacular in terms of providing services, providing pro bono advice. I am not here to criticize my brothers and sisters in the bar at all, not for that. They've been very generous. But the fact of the matter is we've thrown billions and billions of dollars at the access to justice problem, and it's gotten worse. It's gotten significantly worse. The model that we have in place simply doesn't work. We need a market-driven solution, in my perspective. So know that, get informed, and get involved.
Great. And one other question, and then we could start moving along again. Someone's asking, who was the main driver of these initiatives in Utah? Was it the government? Was it the Law Society? Where did these initiatives come from?
So primarily, well, let me, depends on which initiative you're talking about. So as a whole, though, right, they came from the court. And a Chief Justice really focused on access to justice. The conversation started in about really started in Utah in about 2015. There were some legislative efforts to push the court in that direction. And there was also a movement at the ABA at the time with one of the subcommittees, the Subcommittee on Innovation. And those things kind of coalesced to really kind of kickstart the court's programs. And I was fortunate enough at the time to get appointed to the court shortly after that, and picked up kind of the access baton, which is something near and dear to my heart, and I've been running with it. Let me step back, and I'll give you some more details on the history as we work through. There are four things that we've really done since 2015 in Utah that I think are worth mentioning. The first is taking a page out of Ontario's book and building a licensed paralegal practitioner program. We launched last year. We're new, we're just up and running. And as of last week, we swore in 9 more, so it's 13. It's a small number compared to Ontario, but we're making progress. We've just put out for comment a set of rules that will greatly expand who can become a paralegal practitioner. So instead of just paralegals, now taking in people that graduate with a master's in legal studies that the University of Utah adds. It's a 1-year program. Looking at, to the extent that there are bachelor's degrees or others in legal studies like the University of Arizona offers, to build those into the university system here and allow those. We've expanded the types of paralegals and kind of permanently looking to implement the grandfathering clause. So starting small, but the program's built. And hopefully, I'd like to see a few hundred. It's a small state, remember, so a few hundred within the next few years. As a direct result of the LPP program is form reform, taking all our forms, combining them, putting them online, and putting them in plain English so that anybody can use them. The online dispute resolution system that Hirsch mentioned a minute ago, taking small claims court. We're in the process of making all small claims in Utah run through the ODR platform. We've been piloting it for some time, very pleased with the results, but really, taking a page out of Richard Susskind's book and making court a thing, not a place, bringing justice to the people. Right? But the biggest step is reimagining the regulation of the practice of law. Next slide. Let's skip this one. I think we've hit on it. All right. So as I mentioned, actually, let's take a step back. This idea was planted in my head and John Lunt's head, then president of the bar, by your next speaker, by Gillian Hadfield, who was presenting in Washington in the May of 2018, and we heard Professor Hadfield speak then. In response, John, and then passing the baton on to the next president of the bar, Dixon Burton, sent a letter to the court asking the court to form a joint task force to study regulatory reform. 2 years later, August of this year, we launched. So we know from looking at other jurisdictions that there's overwhelming public support for this effort. Arizona commissioned a study of its citizens, and they found that over 80% of the public favored allowing non-lawyers, think LPPs, to offer legal advice, and over 60% of the public favored allowing alternative business structures, non-lawyers to have a hold in legal firms. We've seen overwhelming institutional support for these changes. My court is unanimous on this program. The Conference of Chief Justices is unanimous on regulatory reform. And the ABA House of Delegates, and when I say regulatory reform, let me be clear, perhaps not the same reforms that we've implemented in Utah, but in taking a look at, right, and reforming regulations. The ABA House of Delegates voted overwhelmingly for reform. Again, admittedly a watered down resolution, but still a major achievement. In fact, and I believe it was the head of the New York delegation, and those of you that heard me speak earlier have heard this, that kind of came around and said, listen, this is not just the right thing to do, it's the moral thing to do. Next slide. So once we started moving down this road, there was a change in bar leadership. To be candid, the new bar leadership was not quite as supportive as that launched the initiative. And they put together a separate group to look at what we were doing, to evaluate our work. And certainly the group was populated with some people that were supportive, but a lot of people that were really not supportive of our efforts, at least initially. I've pulled the money sentences from the report because it highlights something that I have found and truly believe, that if you sit down and you honestly evaluate the issue, you reach the same conclusion that we have. So forgive me for a minute as I run through this. The money sentences. We recommend that the Bar Commission respond to the Utah Supreme Court with wholehearted support for their hard work and admirable efforts to increase access to justice, and in support of a limited and controlled environment like the Sandbox, where innovations to increase access to justice can be entertained, experimented with, and hopefully proven successful. The Utah Supreme Court is a leader in taking concrete action to address the lack of access to lawyers for the indigent and the poor, and our committee applies their hard work and countless hours put into the proposal. No one can credibly oppose these aspirational objectives and the wisdom of a controlled environment that with proper oversight, regulation, and reporting will protect the consumers of these legal services. Putting a corral around the unintended and unanticipated consequences, however, that may be injurious is and should be an essential aspect of the Sandbox. So again, I think at the end of the day, if you come to the issue with an open mind and a good heart, the answer is obvious. Next slide. We're not alone in Utah. I'm sure you know, Arizona has voted to change their rules to allow for alternate business structures. California is in the process of evaluating the Sandbox model. And I'm told Illinois, Florida, and at least 10 other states are in the process of evaluating and making recommendations for reimagining the practice of law. It's catching on, and it's catching on like wildfire. Next slide, Hirsch. All right, I have this one titled Writing on a Blank Slate. Why? Because I believe we are the first legal regulatory sandbox in the world. And what I want to take a few minutes to talk about is how we've kind of structured the sandbox and what the sandbox is. But I want to pause here again for any additional questions.
Sorry, there are questions, but I think we are all fascinated to hear about the Sandbox. So
okay, let's move on.
Why don't we start talking about the Sandbox, and then I'll whip up a few questions.
Go for it. Okay, so the Sandbox really is an idea where you have an opportunity to pilot ideas in a controlled environment where data is gathered. And if your idea proves out, you can exit the Sandbox and you're licensed to authorize these services without running afoul of UPL restrictions. Important to note that the Sandbox that we're running is a pilot of itself. We're studying it internally and also having 3 or 4 external teams come in to evaluate the Sandbox as well. We're looking at about a 2-year period for the evaluation before we make any final decisions. Now, in order to make it successful, however, we understand that nobody wants to invest their money early on to be told that the plug's being pulled on them in a couple of years. So those that participate now and that are approved, they'll be grandfathered regardless of what happens. How does it work? All right, well, it's pretty simple. You have an idea. you tell our innovation office, the IO office, what you're proposing. You and the innovation office then identify what kind of risks there might be for the consumer in your proposal, right? And the office sitting down with you then will decide what kind of data needs to be provided and what type of disclosures you need to make. And this is driven by kind of a risk model. You know, where do we think you fall along the low risk, low to medium, high risk, and these categories are defined. For anyone who's interested, you can find them at sandbox.utcourts.gov, and they're described by categories, what falls into each category, what kind of data needs to be provided, what kinds of disclosures need to be made. Once the IO and you have sat down, done the evaluation, the innovation office will make a recommendation to the court whether or not to authorize. See a typo in there. And then the court will decide whether to authorize or not for participation in the sandbox. And then the IO watches for harm. It looks at what's going on, right? Has anybody been hurt? Is it helping? Next slide. So what kind of data is the IO focusing on and gathering? So number of people served, and broken down by the type of service, you know, by forms, chatbots, lawyers, non-lawyers, geographic information. We recognize that there are justice deserts, particularly in places like Utah, revenue and receipt information for the companies, customer complaints, expert reviews that we may conduct depending on the level of risk associated with the project, non-financial outcomes, tracking relevant outcomes across cases, data returns on arrow fixes. You can see financial outcomes, really just about anything you can imagine. We want to collect data on in order to evaluate the project and the particular service that's offered. Next slide. All right, who could we see? So we could see traditional law firms and legal nonprofits that are offering new service models. So using technology that has AI built into it, using lawyers. We see legal tech startups, those that are have primarily non-lawyer ownership, right? New offerings by well-established companies that aren't firms, think Walmart, and community organizations that are offering frontline services. So this is one of my favorites, and I think may have the biggest impact. Think about the possibility of having librarians, church workers, social workers that can offer legal advice. So, you know, one of the things that I've been pushing for example, is to have law students track a group of social workers. Catalog the questions that those social workers are asked in their workshops back at the law school, figure out those that have a legal bent to them, turn around with those questions then and build a course for the social worker, offer the course to those getting their LCSW or MSW. And if you take the class, you're offering legal advice and you're doing it in good faith, immunizing them then from any potential liability for that advice. But I really want to see these community first responders, again, the librarians, the church workers, the social workers, the health workers, those involved in workers' organizations, being authorized to provide kind of limited legal advice. I think that would be a major step. Next slide. All right, current status. So the office is up and running. We're up and running as of August of this year. There's a board that includes lawyers and non-lawyers appointed by the court. And the team that makes up the innovation office includes an innovation director, or excuse me, an executive director. That is Lucy Rica. Currently, Lucy was the executive director at the Center for the Legal Profession at Stanford beforehand. And then for family reasons had continued to be a fellow, and was working with the Institute for the Advancement of the American Legal System. And I'm really pleased that she decided to take on the role as executive director. We have a data analyst and a project manager working as well. We've had 28 applications. We've approved 11 entries into the sandbox already, and we're averaging about 2 a week. And let me just give you a couple of examples. So One Law is a Utah law firm that's using a software platform and chatbot non-lawyer providers and lawyers in a tiered service system. So think coming into the system and having, a kind of some AI driving your legal advice, and then moving on up to, depending on the question, to some non-lawyer providers providing your legal advice, and then to lawyers. And there's outside investment as well. I believe more than 50% outside investment. LawPal, same thing, more than 50% or split outside investment. Lawyer, non-lawyer, tech developer, building software platforms for civil forms using AI to flesh out all kinds of forms that are available online. Basically, we have something in the family law arena, and I think that's primarily where they're focused. Law HQ is a firm that's building an app for consumers to opt into spam mass tort litigation. You get a spam call on your smartphone, you swipe right, and you've reported it, and you're into the litigation if you'd like to be. What else we might see? One of my favorites is that I'm hoping to see. They've made a presentation to us is, for example, an expungement program where the software would alert you if you're eligible for an expungement using AI. It would help you flesh out the forms. It would communicate with the databases, the state databases that have and get the necessary documentation dealing with the criminal charges, and then electronically file it. I think that would be a massive benefit to the people. All of this for free, by the way. Next slide. All right. I think that puts me at questions and really where I want to be.
Justice Himonas, I have a couple of questions. Let me put my lawyer hat on.
Okay.
And say, you're going to open this up for entities not wholly owned by lawyers. Is that going to cost me money? Is that going to diminish my future?
So the answer is no. If we look at the data, right, that we have from England, for example, as I understand it, no diminishment in the number of lawyers, not a diminishment in the growth rate, not some incredible monopolization happening within the firms. So lawyers are doing just fine. And I don't see the economic harm. And I think the reason why is we're trying to figure out, there's a huge unmet legal needs market. And the idea here is to figure out how to help not only non-lawyers, but lawyers also be able to tap into that market, right? And the structure that we have in place, this prescriptive structure with non-lawyer ownership, that's a real problem if you think about it, because what was speaking this week with an individual who runs basically a legal insurance company in Norway. And for 5 years, the first 5 years, they lost money. And now they're successful and they have about a 10% margin. And they're helping the average person with a small rate be able to deal with their services. But they could never have done that under the existing model because we're distributing cash every year. Law firms are cash poor, right? Based on the current structure and tax structure, they're not set up to make the long-term investment in technology or new platforms that's really necessary. But if you can, I think that Norway example is an example of how you can be successful as a business if you have a business model in place that allows for that kind of investment. Now, having said all that, the other thing I'm going to say is Chris, well, and if I'm wrong and you do lose a little bit of money, tough. I mean, I don't. That sounds harsh, and I don't mean it to sound harsh, but at the end of the day, it's not our law; it's the people's law. And if that's, and I truly believe that's not the outcome, but if that's the outcome, morally speaking, that's still the right thing to do.
Yeah, the law, the justice system doesn't exist to make sure that Chris Bentley makes as much money as he wants to make. It exists to protect the people and the businesses in the jurisdiction. And one of the points you've made with the stats you started out with is that there's a huge unmet legal need. And although some people will never have the money to afford legal services, a lot of the people have money. They just don't have $300 to $500 an hour for proceedings that never end. And different ways and different approaches, such as the ones you're going to experiment with in the sandbox, will open up markets for lawyers and for others.
Yeah, or you may not have the tools to allow you to deliver the service affordably. But if you could make the investment in that new technology or new platform and be able to bear that out for a while, then you do, right? And that's, I mean, once you can scale it, once you can get it big enough to scale, yeah, then I can turn it around. Again, using the Norwegian example.
Now, in my opening, I spoke about non-lawyer ownership, this notion of non-lawyer, which means essentially everybody who's not a lawyer is prohibited in Ontario and many other jurisdictions from owning even a little part of a law firm or a lot of a legal service delivery, supposedly because a lawyer's ethics will dissolve if we work with an engineer or a doctor or a business person or anybody who's not a lawyer. I've never understood that as being anything other than protectionism, which isn't working. Are you aware of any evidence whatsoever that if I work in a business with somebody who's not a lawyer, that my ethics will dissolve? And if you are, should we then extend the prohibition to any lawyer sitting on the board of any company that's not wholly owned by lawyers, or to lawyers working in corporations delivering legal services to the for-profit corporation?
Yeah, you know the answer to this as well as I do. There is no evidence of, at least that I have ever been made aware of, that there's an increase in disciplinary issues when there's non-lawyer ownership. And the example that you use is the one that I like to use. We have a lot of our fellow lawyers that are in-house counsel or in corporate legal departments. And, you know, I would give the same kind of response. And it makes sense. I had someone explain to me, you know, lawyers have it upside down. They think that if outside money comes in, that their ethics are at risk. But from the investor's position, it's exactly the opposite. These VCs and others, the last thing that they want to do is invest a bunch of money to have it risked by inappropriate behavior. So, you know, I've not chased down the stats, but they claim that the disciplinary rate is actually lower in those settings as a result of that pressure. So, hey, Chris, now you promised at the outset you were going to make sure that everybody knew that your views were your views alone.
They are.
Okay, so I just could say, for political reasons, you know, I'm not here to tout any government pressure one way or the other.
Oh, no.
I'm just teasing you.
My views are my views alone, and I stand by them. But I find it interesting, you know, that what we've accepted in law as established truth is being challenged by people in positions such as yourself, you know, judges, leaders of courts. You don't have to change, but you are changing because you see the opportunity that change brings about.
Yeah,
I find that interesting.
There's an injustice happening. I mean, let's own it. That within the legal system, that the system and the status quo has some systemic problems with bias, racism, excluding those of less means, or even for those that have ample means, just creating kind of a system that doesn't really work. Like I said, you don't trust lawyers, you can't afford them, or even if you could, why should you have to? Why should this be your only option? You know, there's data doesn't support the notion that the lawyers are offering, you know, type A service and everybody is offering, you know, tier 3 service. That's not borne out.
And just Hirsch, I know you've got some questions. Just the regulatory driver in Ontario, the government has legislation, and that's why our calls to the government. It's different in different states in the United States, where I understand in Utah, for example, the judiciary has a lot of control over the different laws.
We have plenary authority over the practice of law. So in many states like Utah, that's the case. In others, it's more like Ontario, where the legislature may control the access points.
Hirsch, you had some questions there.
Yeah, so there are obviously a lot of questions coming in. I have a very quick question and then a longer question. One question, which I think is very interesting to a lot of people on this call right now, is your sandbox opened internationally to companies and startups, or how does
Yes,
that process work?
it's
Yes.
open to anyone.
Great, fantastic. And there have been a lot of questions around.
You may not be able to get to the website though from outside. Professor Hadfield can speak to this because it's not GDPR compliant right now.
Okay.
So new website coming.
Okay. Okay. So there's been quite a few questions around. Nicely put, what's some of the feedback that you've received? Other words have also been used around pushback and stronger from the bar and the law society around what you've been trying to do. And there's also been questions around how have you been so successful in building some of the partnerships that you've been able to do to get this across the finish line?
Yeah. So lots of slings and arrows. The comments from the bar ran about 2-1 against, right? Lots of people really vocally for, but the majority against. But the majority that, despite incredible outreach and intensive efforts, not really familiar with it at all. Didn't really, I mean, they'd see it and just didn't, interest them enough to really get involved in. So we're seeing a minority of that kind of 30% minority, about 20% of that 30% opposed, 10% in favor of, and the rest, it sounds like just kind of, a bit agnostic, I guess. At least anecdotally, it seems to me it drives down as we talk about the actual entrance and what's really possible, right? Like all of these that I've talked about so far have a heavy lawyer involvement. And once you can see the wheels start turning and folks like, oh, okay, the sky's not falling and I might be able to do something about this. That it really seems to soften, dampen criticisms. In terms of the success, I just keep knocking on wood because who knows what's around the door. I would have to say, I really have to give credit to bar leadership that was in place at the time, John Lund in particular, and then his successor. That's a lot of courage, right? That's a lot of vision, seeing where the future of the profession is and understanding that the profession, that the first principle has to be, fealty to the public and the public good, and not to lawyers as bar leadership. That's big. The second is the court. The court has been unanimous. The chief completely supportive. I couldn't do what I do if I didn't have that kind of support. And the third might be just being an early entrant and getting people like Professor Hadfield, Rebecca Sandifer, and others, just world-class talent that were willing to dedicate so much time to helping us make this lift.
Great, thanks. Sticking back to the Canadian sandbox, we've had a few questions, about the sandbox. We've had a few questions of, are there any best practices that you would recommend if people up here would be thinking about opening up sandboxes? Anything you do differently, anything you would definitely do?
No, and I'm not the right person to ask for that because I think Lucy Rica, much better source for kind of day-to-day boots on the ground, right? Running the sandbox.
Great. Okay. Another question has been around, and it's one that us at the Legal Innovation Zone talk about all the time. Access to data is so important, both for overall access to justice, but also for startups to be able to offer some of the solutions that they want to offer. I know in many, many jurisdictions, getting access to data out of the courts is extremely difficult. And often when it is possible, there's either a monopoly over who owns the data or it's quite expensive. Have you looked into access to data? Are there any plans on making it more accessible? Do you know of anyone else in other jurisdictions making that more accessible?
Yeah, so there are certainly that's an excellent point, an excellent question. There are a couple of things going on right now. One is Tanina Rothstein, a professor at Georgetown, and a big data scientist colleague of hers at Georgetown, are making a push across the country and the states to get the data, stick it in Fort Knox in a way, but I mean, so that it's safe and clean, right? But at the same time, now you can actually access it for these purposes with the state's approval. So it's the first really kind of systematic approach that I've seen. And so far, it's been a slog. In Utah, particularly as we launch, we're launching an office of fairness and accountability, which is really driven towards trying to work on systemic bias and racism in the system. And I think providing data is going to be key to that. But we've not turned the key yet in terms of providing all court data to everyone. We do provide a lot of it, but we need to be better about it, frankly.
Justice Himonas, as we come to the end of our time, can I just ask if you're sitting here a year from now, what do you hope to see in Utah, and what do you think you'll see?
I hope to see and will see, again, knocking on wood if things, a lot of entrance in the sandbox. I haven't researched this to make sure it's true, but I've heard that, when they opened the FinTech sandbox, I don't think they have any entrance in Utah, and that happened a couple of years ago. I said, we're getting about 2 a week. I expect that to continue, if not grow. What I hope to see, though, are more high-risk entrants. That's what we haven't seen yet. It's early days. But the social worker, right, the community first responder, the non-lawyers offering innovative legal services kind of thing. Now, those are the riskiest, but they also offer the biggest potential reward, in my opinion.
Well, that's interesting. I really, really appreciate your leadership on this. And I understand the skiing is great.
Yeah, that's right. So, and one of the things that we've decided as a family that we can do is ski safely. So it's season passes for all this year, and well, really, thank you. Your speech at the outset is inspirational. And it's the kind of call that we need to make, and the lawyers have to continue to make. I'm going to take just a little issue with what you said about, it's about talking matters, but the action matters more. When it comes from a lawyer, it is an action, right? When you are addressing others, it's not just talk. For me, it moved the needle in a big way in Utah. It set the ability for that to happen, and I think that's key. Without the bar or members of the bar making the push, I don't know that it happens.
Thank you for your leadership.
Yeah.
Thank you for everything. I really appreciate it. Looking forward to hearing from the other speakers today.
Thank you very much, Justice. That was fantastic. And I too am a huge snow fan and ski fan of Utah, and have been there many times. And hopefully once COVID passes us by, I will be able to be there again. But I really appreciate it. And I just want to point out, you said it's not our law, it's the people's law. And that, I think, has really stuck with a lot of us. So thank you very much.
Yeah, I lifted that line, by the way, from Crispin Passmore, the past executive director of the Solicitors Regulatory Authority in the United Kingdom. And Crispin, if you're there, hello, and looking forward to our Negronis next week. And if you're not, I expect somebody on this seminar to report to you that I gave you proper attribution.
I may have just been emailing with him right now, so he will be on in a minute.
Thank you very much.
Thank you.
And Hirsch will have our next speaker on in about 2 minutes, I think. Thank you. Hi, everybody. As we hear a few notes of what I believe to be the Grateful Dead, Hirsch's favorite band, I'm delighted to introduce our next speaker. Gillian Hadfield has been a leader in innovative approaches to delivering legal services for many years. She is an author, Rules for a Flat World, among others, speaking about the billions of people throughout the world who have a right to justice but no means to obtain it. She has taught at the University of Southern California for many years. She has taught at the U of T before and is teaching there now as a professor. She is the inaugural chair of the Schwartz-Reisman Chair in Technology and Society and the director of the Schwartz-Reisman Institute for Technology and Society, is a leading spokesperson on ethical artificial intelligence. And as you have already heard from Justice Himonas, and we'll hear from others, she has been involved in reform movements in Ontario, in California, in Utah, in many other places. I am delighted to welcome Gillian Hadfield to our conference today. Gillian?
Hi there. I don't have control of my camera. I think Hirsch, you have it. So I do. I am back here. I am behind here.
Well, I can hear you.
Okay. All right. Let me. I'll let Hirsch figure out the camera.
We'll sort it out soon enough.
There we go. There we go. I think we got it now. Okay, great. Thanks for that intro, Chris, and Justice Himonas. I think you're still here. Thank you for all the kind words in your talk as well. I'm so excited about what's happening in Utah. And Chris, let me just join like right from the start. Okay, Ontario, we can do this. We can do this. We just need to get it going. Let me share my screen, and I'm going to address the case for change, which I think Chris has made and Justice Himonas has made already. But let me just share a little bit here. I want to mention that I am a law professor. My PhD is in economics, and I found that when I joined the conversation about access to justice, probably about 15 years ago now, it was being an economist and just adding up some numbers that I think made most important. I've been showing this comic, a cartoon at the start of these talks for a long time. And I think the difference is we're now not just requesting a change to a entirely different legal system. We really are starting to build it. But it is not an overstatement. This is supposed to be funny, entirely different legal system. That is a lot of what we're talking about here. So it's really critical to remember our societies are built on the rule of law, and the rule of law requires access to legal help. And this is the point that is true around the world and within our own jurisdictions. And the fundamental point we need to be clear on is that access is cut off because of the rules that the self-governing profession or the profession that's created by legislation to be self-governing controlled that make law too expensive. Full stop, that's the problem, that it's too expensive. So we need to change those rules. Those rules are governing the corporate practice of law, the division of fees, and our rules about unauthorized practice. And I'll say more about that. Justice Himonas has already talked about that, what we've been able to start building in Utah. So here are some of those numbers that I present, and these are now the Ontario numbers. 64% of family law litigants in Ontario are in court without a lawyer. Now, that's we don't keep track of these numbers very well. One of the reasons we're in the situation we're in is because lawyers don't tend to come to things with a data orientation, and that's a critical move we have to make. We collect some of this data, but the last data I've seen, 64% in Ontario in family law are without a lawyer, and that number jumps to 74% if you look at downtown downtown Toronto. Now, you've already heard the numbers are high, much higher elsewhere, and we may just not be picking this up. It's over 80% in California. It's over 90% in New York, and Justice Himonas mentioned the numbers that are over 90% in at least one district in Utah. Now, here's another number, 48%. That's the percentage of people in Ontario who, when surveyed, this is actually, I think, low and middle income people, but when we look at studies that go across the income spectrum, we don't see a real shift in the numbers. 48%, that's the percentage of people who say, yes, I have a legal problem of some significance that I'm dealing with or have dealt with in the recent past. And if people are experiencing one problem, they're likely to be experiencing more, and the average is 2. This is partly because problems come in bundles. If you lose your job, you may have a family problem. If you've got a health problem, you might develop a collection problem. Problems come in bundles, and the average is 2. The Ontario service, again, this is from a 2006 survey, which I think there may be more recent surveys, but the numbers are not that much different. 12%, that's the number that received some help from a lawyer in managing their problem. So think about that, flip that around, that's almost 90% who do not. 43% of people report they dealt with it entirely on their own, and 22% said they just did nothing to address the problem. And these are problems of some significance. This is, I'm being evicted, I'm not getting paid, I can't see my kids, and so on. Okay, so let's do a little math now. 14.5 million, that's the approximate population in Ontario. If half of those people have an average of 2 problems to deal with, legal problems, that's 14.5 million legal problems that are sitting out there in the province. Again, we don't have good data, but the bits and pieces we can get from surveys that magazines conduct, or bar surveys or law society surveys can collect. Let's put it at $300 an hour for an hour of, as an hourly rate for lawyers who are serving the general population. Many of you will know that that's low for a lot of lawyers. Maybe you can find some who are working at significantly less, but we're going to call that the average. So if you just multiply 14.5 million by 300, you come up with the number $4.4 billion. That's how much it would cost at those hourly rates to give 1 hour to all those people, to give them help with the problems that they face. That is a massive number. And the reason I put that massive number up there is to say, this is not a problem that we can solve simply by figuring out how to subsidize access to legal services. Okay, let's suppose we looked at pro bono. 55,000, that's the number of licensed lawyers in Ontario. Again, just do the math. If we were going to give everybody 1 hour of legal help with their problem, that would come out to 265 hours of pro bono work per licensed lawyer in the province. This is not something that we can address with pro bono and legal aid alone, although both of those things, you heard Justice Himonas say this, it's a very nice phrase, we can't volunteer our way across this gap. The demand for legal help is huge. We absolutely need robust legal aid. We absolutely need lawyers to be providing pro bono help. But that is a massive demand. That's a massive need for legal help. And it's huge, and it's still largely unmet and can never be met by legal aid and pro bono. Now, the problem here is, cost. It is just too expensive. Legal help is too expensive. And there's a reason for that. It's because the conventional practice of law is extremely inefficient. Now, I've done, again, I'm a big fan of the back of the envelope calculation. My back of the envelope calculation is it's about 80% of what's in that hourly rate is, or some fraction of that is inefficiency. And here's why I think that. So this is now, I'm going to show you US data. I don't think there's Canadian data comparable to this to make the point. So this is data from a US company called Clio that provides online and virtual help and office help support services to practicing lawyers. This is based on their actual records of actual billing data. So this is not survey data, somebody estimating. This is actually coming from billing data. And from their billing data, largely drawn from lawyers who are in those solo and small firm practices. The solo and small firm practices are the ones that serve the needs of ordinary individuals and small businesses. So they're our large firms almost exclusively serve the needs of large corporations. Solo individuals, citizens, and small businesses are going to solo and small firm practitioners. So 2.4, that's the number of hours in an average 8-hour day that those lawyers are doing billable work. They're then actually billing for 1.9 on average, and they're getting paid, they're collecting money for on average 1.6 hours a day. So you might be working the 8-hour day, but you're actually only getting paid for 1.6 of those hours. So what that means is even though you might be charging $200 an hour, that's what I use as my average in the US and US dollars, $200 an hour, you're actually only earning, those lawyers are only earning $320 a day. This is not a high income, I mean, given the levels of education that are required in order to practice law, that's $320 a day. That's about $75,000 in revenues into the small law firm, the solo practice, before payroll, paying an assistant, and expenses like insurance and office space and so on, technology. Okay, so that's part of my point here. Is the inefficiency here is that's a lot of hours not spent practicing law and having to charge enough during the hours in which you are getting paid in order to cover off the cost of that service. Okay, so that was data from Clio. This is data from the U.S. Census. It's from 2007, which is the last year for which we have this kind of comprehensive data. And this is across all law firms, solo practices, and all law firms in the United States. They're just arranged in order of total revenues into the firm. So that's what these different bins are here in this bar graph. And I take a look here at the bottom 40% of those law firms. So it's saying those that earn up to $250,000 or report $250,000 a year in revenues. It's sort of just guessing that aligns with the solo and small firm practice serving the individual services market. In that 40th percentile, you can see the numbers here. The average revenues in those law firms are 132,000. This data is actually tracking, the census data is tracking payroll. So after you subtract the average payroll, that's $89,000. Then you have to pay insurance, then you have to pay overhead, then you have to pay for technology and so on. So I guess that's about a $65,000 a year take home, perhaps. We don't know exactly again. So what you want to think about is what is the actual, the hourly rate that the lawyer is actually taking home is something closer to $40 an hour, $30 to $40 an hour on average. But we're charging $200 an hour to get to that point. And that's the point about the inefficiency. We're charging our clients $200 an hour, but most of that is not going to compensate the lawyer for their legal work. That big difference between $240 and $40 is what I labeled not law. That is what clients are paying for that is not compensating the lawyer for their legal work. And that's what I'm labeling an inefficiency. That's what's coming as a consequence of the structure of the small law firm with lawyers in, virtual, but face-to-face, hands-on, customized provision of legal services. And for those of you who remember your demand curve, here's a schematic one. Right, as cost goes up, fewer and fewer people are able to afford access. So I know there's a number of questions that have come up. I saw a number of questions come up in the question and answer in Justice Himonas' talk. Well, what's going to happen if we drive down those costs? Well, there's a lot of people who are not getting any help, who could afford something closer to that $40 an hour. And if we can figure out how to provide those services in a more efficient business model, we can serve those people. And there's lots of work to go around for lawyers, lots of work to go around. And I've done those calculations. I'm not going to show them. Lawyers earn at least as much as they do now in that world. So what's in all that? What is that non-law? What's happening in that other 6.5 hours a day? It's bill hours that are not being billed, hours that are not being paid for, spending time finding and keeping clients, managing client complaints, making investments in legal knowledge and technology and process, continuing legal education, for example. That's what's in that. That's what we need to figure out. How can we make that more efficient? How do we move down that demand curve? So what is it? Why is this the practice of law is cut off from efficiencies achieved in other markets? And what explains the lack of access? Well, it's us. And Chris opened with this. We are responsible for the world. We, lawyers, legal members of the legal profession, legislators who are often members of the legal profession or responding to that, to the views. We have created this problem. Existing legal regulation is preventing the emergence of efficiencies and the technologies that could reduce cost and, by the way, also improve quality. This is not to say lawyers are bad at law. It's saying we're not very good at matching what we provide with what our clients need. That's the definition of quality. It's not, are you great at analyzing law cases or predicting legal outcomes? It's, are you good at matching what your client needs to what you are providing? We're missing those efficiencies and we're cut off from the technologies that could help us. So how is that happening? Well, it's because of the constraint on the business model. Our legal regulatory approach determines who can provide legal services, who can invest in legal businesses, who can invent legal technologies, how legal services are paid for, how legal technologies are financed, and how the incentives for creation are secured. Really critical, that's why I mentioned at the beginning, I'm an economist. Legal regulation is economic regulation. We need absolutely all of the ethical regulation and principles that underlie the profession. None of this that I'm talking about is about undermining the ethical obligations of lawyers. We have to lean into the ethical obligations of lawyers, but we have to recognize that our ethical regulation of lawyers, the ways in which courts originally required lawyers to uphold the rule of law, the commitment to the courts, the commitment to honesty, the commitment to representing clients in their best interests, the fiduciary obligations, all of that is where we started in legal regulation. And it has morphed over the last 100 years or so into economic regulation. And that's our problem. We are now stuck in an economic model that is keeping the vast majority of people from gaining access to legal help. Our approaches presume and bake in traditional lawyering, and that's what's cutting it off. We license lawyers. We have educational requirements. We have bar passage requirements or law society requirements. We have moral character requirements. And tech companies can't become authorized providers. So Justice Himonas showed you some examples of both the types of entities that have already sought authority to provide legal services in Utah, like Rocket Lawyer. Rocket Lawyer is a technology company. If we haven't, we need a regulatory structure that allows Rocket Lawyer to become an authorized provider of legal services in the market. We need to change our rules so that those technology companies can partner with and hire authorized providers. And currently they can't do that because of our corporate practice of law rules and unauthorized practice rules. And this is really quite important. Legal innovators can't access venture capital under our existing rules. And of course, anybody who's building a new technology startup requires access to venture capital to bear the risk of, this is a totally new way of meeting this need in the market. Will it work? Won't it work? Building that is risky and it requires risk capital, venture capital. But legal innovators can't access venture capital because they cannot, a legal provider cannot have ownership by somebody who is not a lawyer. These are basic tools: legal capital, the corporate structure, risk distributions we get with employment. All of those are basic tools in our other markets to promote cost reduction, quality improvements, and innovation. And that's what we're gasping for in law. We need to eliminate or change those rules generating those inefficiencies. I mentioned them before: corporate practice, fee division or splitting, and unauthorized practice. And this is critical. We need to build that new regulatory body. That is what is so important and so special about what's happened in Utah. It gets referred to as a regulatory sandbox, but it's important to recognize we can have regulatory sandboxes that just tried out different variations. Utah has not just created a regulatory sandbox. Utah has built a new regulatory body under the auspices of the ultimate regulator, as Justice Himonas explained, in Utah, which is the Utah Supreme Court. That regulatory body, an office of the Supreme Court, is enabling new business models and new providers by allowing those technology companies, or as Justice Himonas was emphasizing, social workers, libraries, workers' organizations, to become licensed providers. And then that regulatory body has as its mandate to regulate on the basis of actual risk and the actual outcomes that are achieved. So that means looking at what is the actual risk to a consumer of this service. Will they be made better off than what they are now? Remember, the situation they're in now is most people are interpreting all their legal documents on their own, trying to understand the eviction notice on their own, trying to figure out how to manage their family problem on their own, and not with any legal help. So the question is, what's the real risk? What's the outcome? And how do we regulate for that? And that's instead of dictating the business structure and practices. So what we love to do in legal regulation right now is say, oh, well, we think if there was corporate ownership, there might be some distortion in the way that lawyers behave. So we'll just prevent them forming corporations. Let them form corporations, regulate on the back end, regulate what they do, regulate the way we do through the entire rest of the economy, and tailor it to the actual risk. So that's so that we're regulating for the real objective of regulation, which is to protect consumers, not protecting an idea and not protecting a profession. And I'm done. Thanks.
Gillian, that was fantastic. And I love the fact that you're basing it on numbers and data rather than conjecture and anecdote. Can I pick up on one of the last things you said? And Justice Himonas was asked this question in a different way, which is about the regulatory sandbox in Utah, where the court has control, and a regulatory sandbox that might be set up in a Canadian jurisdiction like Ontario, where the existing regulatory body has control. And let me ask a pointed question. If I want a regulatory sandbox, if I want to experiment, do I want the same body that has said no to regulatory sandboxes, said no to innovation, said no to outside ownership, to have control of the regulatory sandbox? Or do I want a different entity to have control? I just thought I'd ask you an easy question to begin with.
Yeah, I was gonna say, it sounds like a rhetorical question. No, do I think that a law society could get to that place if the law society is created as a regulatory body by legislation with the obligation to, the way I see it, promote access to justice. And if you could have that organization composed in different ways, but it's governed by lawyers, so it's not structured. It's not really structured as a policy body. I mean, there's a lot of reasons that I think it needs to be a regulatory body that does what regulatory bodies do. They should have economists on staff. They should have people who have domain expertise, but they need to be thinking about, yes, we have to evaluate. We need legal expertise to evaluate what's the legal risk. We do need to be thinking about legal risk. We need to be thinking about protecting consumers in the market. So it's very important to say this is not throwing open the gates. Anybody, anywhere can provide any kind of legal help with zero recourse if they do it badly or in malign ways. But what you need is an expert regulator, and it generally doesn't work great to have people regulated by members of the regulated entity, and we know that throughout the economy. There's nothing hard on lawyers to say that.
You know, I understand what you're saying there, Gillian. What many lawyers will hear who don't want change, they'll say, exactly. The reason we have the rules we have is to protect consumers. And I push back a little bit and say, well, who are you protecting? If 8 out of 10 people are not getting the legal services they need and 9 out of 10 small businesses aren't, like, who is being protected? Why would you deny people the ability to access some measure of justice where they can, where now they get none?
Yeah, so I think, so first of all, that's exactly right. And I would say this is, and sure, there's a protectionist strain that runs through all of this, but I've been in this conversation for 15 years. There's a lot of very, very good faith commitment to the idea that we have to protect clients, we have to protect consumers, and we really can't, I spend a lot of time becoming a lawyer. It's very complicated. I have ethical duties. So there's a lot of good faith belief in that model, and I appreciate that good faith belief. It's one of the reasons we want to be focused, make sure we're focused on the numbers, because I think there's no higher ethical duty for the members of the profession than to recognize if 80% of people can't afford it, then that's not protecting consumers. You can't just say, we tend to work with that hypothetical. And this is a really important move we emphasized in Utah. It's very clear now in the governing order for the regulatory body. When you are evaluating whether or not allowing a new kind of service into the market is too high risk, you have to evaluate that relative to what is going to happen for that person if you don't make that service available. You can't compare it to if we had a full-time lawyer, top of their game, as many hours they need, all of that gold-plated, which we all wish we had. And we wish we could have everybody in, the fancy BMW with every bell and whistle and the lane, advice and, so on. But you know what? We can't afford to do that. Maybe we shouldn't let anybody have it, but we can't afford to do that by saying you have to have that BMW. Most people are walking and not getting where they need to go. And that's protecting the consumer has to start with what is going to happen to that consumer in the absence of this service. And we have just not paid attention to that in law.
It's interesting. What are the 2 or 3 changes that you would make in Ontario if the government called you up and said, okay, what should we do? 2 or 3 things.
Yeah, well, I would say, well, we've got a great model now because Utah has really built this. So I really emphasize build the regulator to create a licensing scheme for providers who are not lawyers. I mean, and it doesn't mean that they could be lawyers that join together to form a corporation. They could be and take outside financing. It's really just to say the problem we've got with our existing scheme is you can't get out of the straitjacket because the only thing we got is, take the bar exam, go to law school, take the bar exam, and become a licensee. Well, we need a method for different kinds of business models to become licensed. So that would be the number one would be build that regulator, and that as we're demonstrating in Utah, that's a straightforward. There is a model. Justice Himonas was asked, what advice would you give for how to do that? I'd say, well, let's take a look at what we've got. We've got risk regulation. We've designed a structure there. That would be the number one. Then the only other thing you need to do is, and this was actually the original pitch I made that Justice Himonas spoke to, build the regulator. You can leave everything in place about licensing lawyers and your existing scheme as you want. The only other change you have to make is to say a lawyer who works with or for a regulated entity is not in violation of their license. Everything else can stay in place. Those are the two key moves.
Well, wait a minute. If I'm working in a regulated entity and I own 50% and the business person owns 50%, isn't that going to affect my ethics?
No, it's not going to affect your ethics, because hopefully we did our job right and we trained you well and we licensed you well and you truly are committed to your ethical duties. So first of all, think about so doctors, engineers, working in environments where there's somebody else who's running the business. The status of your employment doesn't change your ethical duties. You still have a duty of honesty to the court. You still have a fiduciary duty to your clients. Stockbrokers still have a fiduciary duty to their clients, advisors, your bankers. So it's just a myth to say that somehow that wipes away your ethics, because if it does, you're not a very ethical lawyer in the first place. If you think you could just be, oh gosh, my employer's come in and told me that I should, hide those documents, not show up in court on time or whatever. The second is, to the extent that you think that there are ways in which the incentives of the corporation, so those profit-making incentives, which of course our law firms have as well, the profit-making incentive of the corporation is going to undermine the behavior of the lawyer. That's what regulation is for. So if you are actually regulating for the quality of the outcome, the quality of the service, and you audit that, you check that, you take complaints on that, and if you as a lawyer are working for me as the owner, like I'm the 50% or whatever owner of the firm, and you allow yourself to fail in your duties to the clients, we get shut down. We lose our license. That's actually why you need a licensing scheme there for those entities, because you do need to have that capacity to say, sorry, you're actually not working in the public interest, and we can take your license.
So if we set up these regulated entities and we allow lawyers to participate in them, even though they're not owned by lawyers, we allow lawyers to invest in them. We allow regulated entities that don't have a bunch of lawyer investors to provide legal services. Is that going to mean less money for me as a lawyer in the province of Ontario if I want to do it the traditional way?
Well, so remember, the traditional way for a lot of lawyers is pretty inefficient. They're not spending their day practicing law. So a key point is to recognize, so suppose we had a rocket lawyer type entity licensed in Ontario to provide assistance with forms, with responding to notices, and so on. Now, one of the first things that entity can do is provide those services by hiring lawyers. So I think there was a question from a young lawyer in the chat earlier.
Right.
Saying, okay, so right now my law students, what are their options when they graduate? Okay, they can try to get one of the law jobs in a big law firm that hires significant numbers, fewer these days, right? We're in a changing market. Or they can find a small law firm, or they can hang out their own shingle. If we had a licensed rocket lawyer, let's say, they could also get a job at Rocket Lawyer. And they could spend their day, 8 hours a day, and actually it would be 8, it wouldn't be 12, 8 hours a day providing legal services. They wouldn't be worrying about, am I getting paid? How will I find clients? How will I build a business? What technologies did I implement? That would be left to the company. So I think lawyers, when they think about this happening, all they see is there's going to be other providers and I'm going to be out of luck because I'll have no work. I think, no. You're going to be building those companies. You're going to be asked to come in and run those companies. And as a young lawyer, you'll be employed by those entities. If you wanted to, you just went into law because you love the life of the small office and to be your own small business person, great. Maybe you'll be able to buy more legal technology to help you. But I think so when I think about like what's in it for lawyers, I say, well, we certainly can't protect a hugely inefficient, it's bad for everybody, business model. If you want to do that, just like if you want to open up a restaurant, you have that choice, high risk. If you want to operate as a contractor, you have all those options still available to you. You will have more options available to you. And because if you increase the efficiency of the business model, so many more people can get legal help. That's a big, big increase in the demand for legal work. That is a boon for the legal profession.
So there was a question that if we allow for-profit entities to provide these legal services that are not lawyers, is that really going to decrease the price for middle and lower income Ontarians of some legal services?
Yeah, so that's why I go through the kind of that back of the envelope math to say, right now, that small firm lawyer has to charge $200 an hour because they're actually only taking that's what they have to charge in order to net out at $40 an hour for the day. So now let's suppose we can have somebody else take on the business. We can use technology to get our, advertise our services and help people find lawyers. Right now, people don't even know how to find lawyers very effectively. If you increase the efficiency of that, that's what drives down the price, right? It's not lowering the return to the lawyer. It's just saying you're going to spend fewer hours running around trying to find the clients or trying to collect from those clients or, figuring out which technology to use. We're going to be able to build brands. We're going to be able to build technology websites. And can that help the low and middle income client? Yes, absolutely. Because remember, the person who is representing themselves in family court, right? Okay, they cannot afford anything close to the lawyer providing the conventional, traditional style of services. But can they afford something at a lower rate that at least helps them with their documents, that helps them understand what's happening, maybe gives them advice over their phone? Yes, they can. And we still need legal aid. We still need support for people at the lower end of the income distribution. Absolutely.
Let me ask this question and get your thoughts on this. Let's assume none of these changes come to pass. Let's assume that we continue on the path of our historical path, that only lawyers are able to own or provide legal services. What's the effect of technology, you being the chair of the Schwartz-Reisman Institute? What's the effect of technology on the traditional practice of law going to be if we don't change?
Well, first of all, I think what we will see is that the kinds of, we've already seen this because there's actually quite a vibrant legal technology community that is starting to build. I know Andrew Arruda will be on later. And I've been watching that legal technology community for, again, the past 10 years. Actually, it hasn't been around 10 years. I think it's like 5 or 6 that it's really been bubbling. What I've been really struck by is I meet a lot of legal tech entrepreneurs with their brand new startup idea. And what they want to do is say, I want to build the phone app that will take a picture of somebody's eviction notice or take a picture of somebody's employment document and give them clear, easy to understand information about what's in there. I use that as my example, my favorite app that I want to see. Okay, we actually have those things. What those entrepreneurs figure out pretty quickly is they can't sell that app at, say, let's say a $5 subscription rate a month or something, or whatever. They can't sell that app because they can't sell that directly to the consumer, to the person who needs it. They can only sell it to law firms. or to in-house legal counsel in big. So all our legal technology shifts from wanting to address our big access to justice gap, and that's a big, big addressable market. There's significant value there to build for, and it shifts it over to the corporate side. So I think the point is that the legal technologies we will see will be those that, you know, have to root themselves in. They will mostly address the large corporate market. I think they still won't even be as valuable there as they could be. But when we're thinking about the access to justice side, the small firm, the small business, the ordinary person, we won't see those legal technologies built. And I can tell you for a fact, I have talked to all of those entrepreneurs who tell me, well, we started out with this, but we now, we started building our contracting app to help the small vendor, the musician on a gig or whatever. And, you know, there were just too many barriers to that. We've shifted to, you know, a tool that we can sell the in-house legal department.
In the near term, we won't see them built in and deployed in the same way. Do you think in the medium term, they'll just be deployed from some other jurisdiction and people will access answers out of the reach of either the province or the regulatory body?
Well, I think some of those will be, yes, and then they will be outside of the reach of the regulatory body. So so I've been talking to somebody who wants to use one of these big new artificial intelligence language models to read legal documents and provide the interpretation. I keep saying, get to Utah, right? Okay, Utah is not a huge state. It's a gorgeous state. I also ski there. It's a small state, but you can build that technology there out in the open, in an environment that actually is going to end up being able to say, and the regulator was watching and was looking for whether there were problems, and there weren't. You will get that kind of accreditation basically in the market. And then, you know, you can provide that elsewhere, right? You can download that app elsewhere. I would rather see that happening where you've got the Utah regulator will be making sure that it's giving appropriate advice according to Utah law and the Utah community. That's what their job is. We should be, you know, to the extent that there's a risk associated with that, it should be under the regulatory umbrella of those other jurisdictions. But it's a bit like, how did Uber grow? Uber grew because you could put it on your phone in any country in the world, both as a driver and a user, and all the regulators there were playing catch up.
We hear a lot from legal leaders who oppose change. We don't hear much from the newer entrants to the bar, the people who have more of their future in front of them than behind them. A number will hear what you say or what I said and worry that we're trying to diminish their futures. We're going to make them poorer than they would be, and they pay a lot of money to get there. What do you say to them?
Well, I mean, so this is the pitch I make to my students when I'm teaching first-year law students, or, you know, I teach legal innovation classes and so on, legal technology to the upper year students. Say, this has to be what you take on. You have to be the generation of lawyers who does this. And I think the reason we don't, you know, we don't see that coming from, we don't see that coming from that generation yet so much, although we've certainly got some very, very creative, and I'm just, you know, I'm always so impressed by the energy. You've got them at Ryerson, right? You know, I've talked to your students as well. There is great energy. Now, they can't get the venture capital that their friends who are graduating in computer science and engineering and you know, even public policy or whatever, they can't access that because of our rules. They've got this very, very limited environment. And for the ones who are not as driven in that technology sense from the beginning, I also read the application essays that we get from students wanting to come to law school. And I don't know if you've looked at them, Chris, but, you know, I'd say 75 to 80% of them say the reason I want to go to law school and become a lawyer is to help people who need help. And only some of them are saying that because they think that's what we want to hear. That does motivate a huge number of our young people coming into law. And then I think we fail them because we slap them down in a legal education curriculum that hasn't changed, for 100+ years. And we slap them right down and say, okay, we're going to train you to be a member of the profession. My job is to teach contract law. I feel an obligation to do what's expected by that curriculum, which is train somebody to argue and advise on contract law cases. We never put these numbers in front of them. We don't teach them about the structure of it. We don't teach them about the fact. It's a big surprise. I'm sure it's a surprise to a number of people to see that, even on this call, to see the percentages of the population that have no. Now, just imagine that was the medical system, which it was at least in the US in the 1930s. 90% of people in the US in the 1930s, it was fee for service. 90% of people didn't have access to doctors except charitable services. That's what we're saying today for the vast majority of people. I think our young lawyers just don't have an opportunity to learn about that. And then when they do, they don't know what to do. They don't know where to go. And what they come to me and say, what should I do? I said, well, I hate to tell you, the only thing you can do is be part of the movement to create the space in which you can go out and actually figure out how to help more people. That's what you want to do. It's totally doable.
To build your future. And on that note, Gillian, thank you so much for this. Really appreciate it.
Very happy. Thank you, Chris.
Great insights, great numbers. And to all of our listeners, we're going to be back after a half-hour break. Hopefully you'll join us then. Thank you again, Gillian.
Thanks very much, Chris. Thanks, everybody.
Get a real-time bird's eye view of your projects. Create project.
So we'll just deal with a few technical, the few tech gremlins who have invaded the system. Of course, you have to have a few tech gremlins. What would a tech conference be without a few tech gremlins who invade? But we'll sort that out. And in the meantime, I am delighted to welcome our next speaker, Justice Timur is the Vice Chief Justice of the Arizona Supreme Court. She has been a judge of courts in Arizona since approximately, I believe, the year 2000 on the Court of Appeals for a number of years, Division One. Before that, in private practice. And for our purposes, a driver in innovation in Arizona, in many ways leading the United States into new territory. I won't say completely uncharted territory, but certainly for the United States, new and often uncharted territory, and a very exciting time. Welcome, Justice Timmer, to our conference. There is probably a little unmute button somewhere.
Okay, there you go. Yeah, sorry about that. Unfortunately, talk about technical difficulties. My cursor would not go to this screen for some reason to unmute. So I was caught.
We've all been there. We've all been there. So welcome. We're delighted that you were able to take the time.
Well, thank you so much. I have a PowerPoint to kind of guide my remarks. It's not extensive, but am I able to share my screen to show that? Yes. Okay, if I can get my cursor to cooperate, which is an iffy thing. Let's see if it works. Okay. It's not working.
It will.
Okay. Let's see if that works. Okay. And are you able to see that?
Not yet.
Not yet. All right. We'll try again. How about that?
Ah, perfect.
Perfect. Okay, from the beginning then. Okay. Wow. Great. I'm delighted to be here, and so I was asked to talk about. I guess your group is talking about regulatory reform as well, and I know you've heard from my good friend Justice Himonas so far, and we're always ready to catch up with Utah. That's one of our goals here, or at least go side by side as much as we can. So first of all, I always have this as a reminder that really the courts in Arizona and elsewhere in the United States regulate the practice of law in our respective jurisdictions. So we have to bear that in mind, that anything we're doing is with this regulatory hat on. And I answer that usually to groups of attorneys who are saying, well, what's this going to do to the practice of law? And will we be as competitive? And all of these kinds of things, which I'm always happy to answer, but I bring them back from the starting point that from our perspective, it's do the rules and the market as shaped by our rules impede the legal services to the consumer? And is there a reason for some of our rules that is necessary to protect the consumer? So I kind of bring folks back to that point continuously. So what have we done in Arizona? The first thing we've done is, does this work? Well, I had animations, but fine. We went ahead and limited our ER 5.4, which is what said that you cannot share legal fees with non-lawyers. And so I know that you've heard from Justice Himonas that they've gone with the sandbox approach, and we considered that, but decided instead just to go ahead and take the gloves off and eliminate that ER. It will permit then non-lawyer ownership and investment in the entity providing legal services. The three most common concerns that we heard as we conducted our task force looking into this was, if you eliminate ER 5.4, then that will be threats to lawyer independence, client confidentiality, and conflicts of interest. There's a lot of academic debate about whether that's really so. Some of it says that the origins of that ER were really to try to make a more protective group for attorneys to just, guard their share of the market rather than really protecting the consumer. But regardless, hearing that, we of course don't want to harm any of those three things. So we amended other ethical rules to bolster those three principles throughout. So we've strengthened those, and after doing so, there really is no need for ER 5.4. One of the things, though, that we said that if we're going to do that, then we want to regulate entities. And I should back up a little bit. After I had chaired the task force, which looked into the regulatory reforms, and the court met this past August, end of August, and adopted them. So that will be in effect January 1. The first thing that I wanted to talk about is the alternative business structures. So I said, as because we've eliminated ER 5.4, we will do so as long as we can regulate these alternative business structures, so ABSs, if you will. The court does not regulate law firms, so that's important to, I don't know how it is in Canada, but we regulate lawyers, but not traditional law firms. So this will be the first time for us regulating entities that are involved in providing legal services. So we had to structure something around that. What we chose to do is adopt this in our court code. So we have something different. We have court rules, which are more in cement, if you will, and they're looked at once a year. People can petition to add rules, modify rules, that kind of thing. And it's not a very facile process. We have to take public comment, and it just takes a while for rules to change. But we have a code of judicial administration where we really then, that's just the court can change very quickly if needs be. So most of our regulatory weeds, if you will, are in our code of judicial administration. And we still put that out for comment and such, but we can make changes there more quickly. So I went ahead, especially with something new like this, and put into our code to build it out. Our rules allow for it generally. Our code really builds out the structure of what it looks like.
And just to let you know, Justice Timmer, not that it matters, the side slides are on the screen.
Oh, are they? Oh, well, no wonder my thing's not working. Sorry. Okay. Hey, there you go. And I will catch up. And all my fancy animations will.
Yeah, your notes are showing. I think there's a. No, I always get confused stuff, but.
They go away?
No, the notes are still there.
There? Oh well. Doesn't matter. I'm not reading off those notes anyway, so. It's an old notes that I've changed. All right. So anyway, our code. First thing it does is licensing. So we've set it up that our administrative office of the courts, which is the adjunct of the court that really does the administration, our certification and licensing division, which currently certifies lawyers, it certifies licensed fiduciaries. We have something in Arizona called document preparers who are allowed to assist people in filling out forms. They can't give legal advice, but they can assist in filling out forms. They have to be certified and licensed for whatever reason, which surpasses my knowledge. We certify defensive driving schools when people get tickets and other things. So we already have our certification licensing division set up. So it's seamless for us to put in this certification licensing of ABS in that department. So it will be done by them. One piece of, and when we set this up, we were very cognizant of warnings that we'd gotten, or advice rather, from our governor's office, who we had checked with them because they're very much into re-regulation and a number of businesses, and said, what advice could you give us in re-regulating an industry? And they said, don't over-regulate. That's something that's the temptation when you remove a rule like we've done, to build in so many roadblocks to ensure that people won't get ripped off or abused, that it just becomes insurmountable and nobody's really interested in joining into this venture. So that was a wise words that I pass on simply because if you all are interested to think in those terms. So when we license, what will that look like? Well, first there has to be an application process. The application will require information about the regulatory structure of the new entity. So the ownership, who's going to own this, who has more than at least a 10% interest. There are certain people who cannot have more than a 10% interest. And those are folks like lawyers who have been disbarred or who've not passed character and fitness in the first place to be licensed. And there's a number of other things that essentially revolve around have you defrauded the public in the past? So people that fall into that genre, just as they wouldn't be licensed to be an attorney, they're not going to be able to be part of the ownership of a licensed ABS. The application then will also require satisfaction of certain objectives, or at least information about objectives that are set forth. And I'm just going to read the objectives, that they are certainly a business entity and structure. You need to know all of the affiliations, details of every person with an economic interest I mentioned, acknowledgement by all authorized persons that they are going to submit to regulation by the Supreme Court. Because as I said before, we're not authorized to regulate any entities other than lawyers. So the ABSs would have to submit to our regulation and submit to not only that, but are following our code of conduct and our discipline system as well. There are other things that they have to have an entity representative and statutory agent, be in good standing, and that kind of thing. The objectives that they need to list are things like, I'm getting a little bit ahead of myself. When they file their application, it's going to go to a new committee that we have identified, committee members, to decide whether they should recommend that the ABS be licensed. And the Supreme Court is the one that ultimately will make that decision after getting the recommendation from this new committee. So the new committee will look at particular factors that have been identified in the code, and the application should speak to those as well. So number one, the decisions of the committee must take into consideration these following regulatory objectives: protecting and promoting the public interest, promoting access to legal services, advancing the administration of justice and the rule of law, encouraging an independent, strong, diverse, and effective legal profession, and promoting and maintaining adherence to professional principles. The committee needs to examine then whether an applicant has adequate governance structures and policies in place to ensure that the lawyers in the entity who are providing legal services to consumers, that they will act with the independence consistent with the lawyer's professional responsibilities. They will maintain the proper standards of work in the ABS, and that the lawyer will make the decisions in the best interest of clients. So that kind of thing. I mean, the idea is that the ABS has to give some type of assurances that they have the structure in place, that the lawyers will not be required to violate their ethical obligations. As part of that, a lawyer who is actually employed by the firm has to be designated as a compliance attorney and identified yearly on materials that are filed with the court. The compliance attorney is someone who has special responsibilities, essentially to ensure that all of the ethical rules are abided for, that they're appropriately supervising the non-lawyers in the ABS to assure compliance with the ethical rules and codes of conduct, most notably in the areas of client confidentiality, conflicts of interest, that kind of thing. That the compliance attorney must ensure that the ABS establishes policies and procedures in the firm to, among other things, protect client confidentiality, avoid conflict of interest, ensure that all the owners of the ABS comply with a code of conduct for ABSs, and notify, obviously, the state bar if there's going to be a change in ownership interest and that type of thing. So if you pass the application process, it goes to the court to decide, and you will get a license number and certificate, which needs to be placed on all documents that at least are filed with courts. And I should make clear, in case there's any question, only lawyers may practice law. in Arizona, even under this system. The non-lawyers in the firm cannot practice law. So regulating, that's the next thing that will be done. We have regulating the entity. We'll consider codes of conduct that we've developed. They're also set forth in this code provision 7209. And it's essentially avoiding conflicts of interest, that kind of thing, and following loosely along our rules of professional conduct, not taking any action that interferes with the professional independence of the lawyers or others authorized to provide legal services, ensure that the legal services are provided diligently, refrain from misleading courts, clients, that type of thing, and comply with our ethical rules regarding safeguarding property, maintain financial viability, or begin an orderly wind down. There's also wind down proceedings, and if there's sales and such, there's regulations in place that specifically cover that. The last thing, I think, are disciplines. So we've set up a separate disciplinary system for the ABSs themselves. There were a lot of concerns when we were in the task force part of this, of people saying, well, what's to prevent somebody from partnering with lawyers and then just acting unethically and then letting the lawyer hold the bag, if you will, in discipline. So, and then they can just move on without any type of consequence. And so that's why we set up our specific discipline system for the entity and for the owners as well, that they've agreed to submit to. So the discipline system, I won't get too far into the weeds. I'm not sure how familiar you are with lawyer discipline here, but it will essentially follow the same pathway that we have set up for lawyers. So for us, that's an investigation by our state bar, and then we have a formal presiding disciplinary judge who will hear formal charges and do hearings on that. You can have appeals up to the Supreme Court from any adverse judgments that are issued by the presiding disciplinary judge. What can be done for discipline? The license can be suspended or revoked. You can also, just like lawyers, admonitions, reprimands, that kind of thing. But with ABSs, we also put in that there can be monetary penalties. So if there is really something outrageous, you can have a monetary consequence that will follow the owners as well. And that goes up to, I think we capped it at $1 million. So hopefully that's sufficient to at least disincentivize folks from simply thinking they can move on without a consequence. There can be reinstatement. There's a process set out for that if you're suspended or revoked. Let's see, we've got, and then fees. With the fee structure, we set up on a tiered basis. And so I recommend if you're going to be thinking about that, you should give that some consideration, because there are entities and there are entities. So we've set up different fees for if you're a traditional law firm, that's a defined term, who wants to share fees with, say, your CFO or tech people or anyone, lobbyists, that kind of thing. So different fee structure for them. There's a lower fee structure for nonprofits. And then there's different fee structures for the larger you go or if you go internationally. So it'll range anywhere from the initial fees, I think for application, I think go up to $12,000 for the most for the international firms, and a lot lower for traditional law firms. I think it's $6,000 for them. Okay. The other thing that we did was we went with this new tier of legal service provider. We're calling them legal paraprofessionals, which was not easy to come up with that name. We really spent an inordinate amount of time discussing what to call these people. And we had folks down from Ontario actually to talk about their program. And I know that your program is thinking about, or maybe you're doing it now, expanding it, and is getting maybe a little bit more interest from traditional lawyers because of the expansion. But we were very impressed with the Ontario system when we looked at it, and we've set up a same kind of thing, a code. Well, we will license non-lawyers to provide legal services to clients within specific scopes of practice. And remember, I mentioned earlier, we have what I consider is like a pyramid type of shape. At the bottom, we have legal document preparers who, again, can't give legal advice, but they can just assist in filling out forms that people are doing do-it-yourself type things. And we have about 600 to 700 of those in Arizona, and we've had that since about 2005. So this is considered as a step up on the pyramid, if you will. So now you have a group that can actually give legal advice, including going into court in certain areas. And the way we had looked at it is something that's analogous to how the medical profession has developed, so that you have now, if you have phlebotomists draw your blood, you don't need a doctor. You don't need maybe a doctor to do what a nurse practitioner can do, or a physician's assistant. So, but when you need a doctor, you need a doctor. So it's all kind of set up on that same scale. And that was some of our thinking. And we had some medical folks on our task force for that reason, just to talk about the angst and pains and how that went when that went on in the United States about 50, 60 years ago now. So we set up in the code again, so it can be changed pretty quickly if there are issues that we did not anticipate that need to be quickly reworked. We identified as our limited practice areas family law, limited jurisdiction, civil and criminal, which in Arizona, limited jurisdiction would be our municipal courts and our justice of the peace courts. So I'm not sure you have there, but they're not general jurisdiction courts. So it's basically your low dollar civil matters and your misdemeanor crimes. Civil matters, really, you're not seeing lawyers probably ever in those. It's just not worth their time. Same with criminal misdemeanors that don't involve incarceration, and that's what we've limited it to. So they can settle the consequence, particularly if you have immigration issues and that type of thing from a misdemeanor conviction in like municipal court. And people are really craving some kind of legal advice. But again, it's not really worth it for lawyers to engage in that type of practice. So you just don't see them there. We've also authorized administrative law as permitted by the agency, meaning if it's up to the agency, if they allow legal representation, then these people can practice in those administrative arenas. Family law is probably the most controversial for us because you do see lawyers in family law, but you're not seeing them in the numbers that are really necessary to serve the public. So for example, where I am right now, Maricopa County, which is the general Phoenix area, our most populous county, the last time I looked at the numbers, you have more than 95, I think it's more than 95% of cases have at least one unrepresented party, and more than about 75% have at least both that are unrepresented. So there's a real need here. And what we've seen over the years is people really trying to do it themselves. So much of the effort since I've been on the court has been in helping to develop self-help desks and self-help forms, and they're all used quite a bit. But still, even though we've tried to make the rules as easy as possible, particularly in family law, it's confusing and it's intimidating for people to go to a court. We forget that sometimes, as nice as we all are, that it can be scary, particularly at one of the worst times in your life, probably, going into family and trying to navigate all of that. So family law is one that we've decided to allow, and I think I'm going to have to convince some of our lawyers here. That's probably our biggest PR of trying to get over that. There are some things they're not allowed to do in family. So like quadros, qualified domestic relations orders, which frankly a lot of attorneys don't do, that they will get accountants to help them out on that. They're complex. So unless they're given special permission, they can't do that kind of thing. So licensing, we have two pathways. One is via education and one is via experience. So for education, you need to have an associate level degree in paralegal studies or an associate level degree in any subject plus a post-degree certificate in paralegal studies. if you have a Bachelor of Arts in the law, I know one of our universities, University of Arizona, offers a BA in law. If you have that, or if you have a Master's in Legal Studies, or if you have a JD, as long as you're not, a Juris Doctorate, as long as you're not disbarred or suspended. And then there's some minimum course requirements for the particular subject areas. That's one pathway. The other one is by experience. Again, no disbarred lawyers. But if you've worked in the areas of practice under the supervision of a lawyer for 7 of the last 10 years, and you can get that lawyer to say, yes, this person has the requisite experience level, then you can get it through experience. And that was really to acknowledge that you have a lot of existing paralegals in traditional law firms now that know a lot. And there's really no reason to have them go back and satisfy the education requirements at this point. Whether you meet this by experience or education, you still have to take a test in the particular subject area. So each test, each exam will cover a general legal information and ethics, but then there's a separate portion of the test for the particular practice area that you have to satisfy. And if you pass this and are qualified, then your endorsement will be just for the particular practice area that you have. Let's see, regulating. Again, there's a code of conduct, which is essentially the same code of conduct, the ethical rules that lawyers have, with a couple of exceptions that apply only to lawyers. And you will be an affiliate member of our bar. That's probably the other controversial thing that we have here. Lawyers, some lawyers are rather distressed that that you would have affiliate members that are these legal paraprofessionals. There's a myriad of reasons for that, but nevertheless, that's how it's set up. They will, They will also be subject to discipline, the same discipline system that lawyers have, essentially the same as the ABS discipline system, same for legal paraprofessionals, that they will go through that same with the same type of potential discipline outcomes as the lawyers do. As far as fees, the fees are a lot lower, of course, for legal paraprofessionals. They range anywhere from about, around $300 for initial application. But because they are affiliate members of the bar, they will have to pay a bar fee, which will be set by our state bar, not by the Supreme Court. Okay, and I think I got that in close to on time or enough for questions. So, what questions?
Fantastic. Good. Let me feed you some questions. I'll get you to end the screen sharing.
All right. Oh, and I got to end the screen sharing. Okay.
Just the bottom should be a bottom button there.
I know, medium. Yeah, you'd think, right? Sorry. My bottom has dropped
Really?
out, literally.
At the top.
Okay,
It's at the top.
There's
Perfect.
that. I got it.
Perfect. So let me just start with a few questions. Thank you very much. And encourage anybody else with questions to fire them through the Q&A. First of all, these new rules take effect when? Was that the beginning of January?
Yes.
And really the heart of it is the fee sharing arrangement.
Yes.
The ability of lawyers and those who aren't to share fees on a given case. And am I correct in that?
Yes.
And what you appear to have done is created a regulatory structure for these alternate business structures, and then lawyers can be part of those as equity owners and conduct the practice of law. So let me start with that and say, what's the problem for which you designed these new approaches to delivering legal services?
Well, it came out of really two things. The first, and probably the primary one, was access to civil justice. The civil justice gap that I described briefly in family law exists in myriad places in Arizona and elsewhere in the country, and probably in multiple countries at this point. So that was our initial task in looking at what can we do. And as part of that, we were taken by more innovation, particularly more use of technology and different partnering arrangements. Would that be a better service to the community? So we have, I mean, what's been happening? We have, for example, we have a market that has just gone around regulation. So we have the legal zooms and rocket lawyers and all of that with the do-it-yourself forms, and then people use that, and maybe not very well, because as we've been told by some of those folks kindly, that they can see when people are getting the wrong form. For example, they want to get a conservatorship, they want to control the money of somebody who's disabled, but they fill out guardianship papers. Well, the folks online, they can see that's the wrong thing, but they're prohibited from telling them that. So what we have is just a, I don't know, billion-dollar industry at this point that is going around our regulations. The market will always find a way with nothing from us as far as input. And so that was a lot of the impetus. And then, as I told you early on, when that little top hat, our regulatory hat was on, looking at the ethical rules and then asking those questions of why. Is this, which really our ethical rules are what shape our legal market, as you've heard probably from Professor Henderson, who also came from down to us to discuss it. That's what shapes our legal market. And that is also, what protects the public. So you look at these rules and think, well, is that serving that purpose? And as we looked at it and discussed it and turned it over and over, we concluded it's not serving any purpose. It's except to prevent people from being innovative. So that was really the big driver on this. I'll give you another example, a real life example. When we had the recession here about 10, 12 years ago now, a number of lawyers who were trying to be creative, not only to help their own businesses, but to serve the public, propose things like, could we partner with somebody in real estate and somebody in banking to be like a one-stop shop for all of these homes that are going underwater, and help people out and give them what they need, and then share the fee for that? And of course, the answer is no, you can't do that. Even though it makes perfect sense to have that kind of thing, we had to say, no, you're not allowed because of this ER 5.4. And that's something that could have been extraordinarily helpful. So that's one thing. The other thing on the back end is it doesn't, even though we're out to make sure that the public is served and all of that, we love lawyers, of course, we're all lawyers. And it didn't escape us that lawyers are struggling as well with the advent of technology and such, and this market that is going around the legal profession. Lawyers are having difficulty competing, and they have some need to try to innovate and try to come up with something to not only serve clientele, but help themselves as well. And so we're looking at some of the rules. ER 5.4, again, does it help the lawyers? Is it needed? Is it necessary? Or is it an impediment to them as well? And that's why we decided, let's just get rid of it and proceed the way we did. So that was our twofold motivation for this.
Yeah, it's interesting that in addition to the obviously reaching out to members of the public who can't now access legal services, you spoke about two reasons that actually benefit lawyers. One, it stifles innovation and creativity if you don't have it. And two, it helps lawyers compete for business they wouldn't otherwise get. So am I correct in suggesting that you see there's a win-win in all of this?
I do, and maybe I'm an optimist on this, but I do think it's a win-win. I think that lawyers, I mean, of course, we're all conservative, right? Lawyers are not, by nature, they don't like change. People don't like change. And so the knee-jerk reaction is, oh, we can't do this. This is going to negatively impact us. Same reaction doctors had years ago when told that they're going to have phlebotomists draw blood instead of them. This is going to change our lives forever. Now, if you ask new doctors, rather, they couldn't live without nurse practitioners and physician's assistants. You adapt to that. You innovate. Doctors don't need to own hospitals to practice medicine, and lawyers probably don't need to own the entity that pays them to practice law. So I do see it as a win-win. And in talking with some of the law firms around town, there's been a lot of interest on how can we make this work for us. There's been some smaller firms that were already looking about, okay, this is who we use. I mean, I can imagine a zoning attorney might use some land use planner as part of their deal. A firm that's in government relations might want to use, have a lobbyist. They all have lobbyists now, our big firms here. It's just that they can't give them an equity interest. And so if you want to attract the best and the brightest and keep them, give them a role. Same with technology. If you want to have technology that goes forever, rather than just having somebody come in and sell a system, we'll give them an interest. You know, what can we do to innovate? So I think that would help them. I've told the family law lawyers who are, you know, really feeling threatened with the legal paraprofessionals, why don't you hire some of these legal paraprofessionals and expand the quantity of your practice, that then you can even oversee this, and you can have, you know, have clientele that maybe can't afford you, but they can afford the legal paraprofessional, and you can leverage off that. So I think it's a win-win.
So a couple of questions about the practice of law. I think I heard you say that only lawyers can practice law. So question, if I am an ABS and I'm delivering a legal service, but I don't have lawyers, where does the practice of law and legal service begin and end on this?
Well, if you're providing a legal service, you have to be either a licensed paraprofessional or a lawyer. So okay. There's no, and we define the practice of law and what that means. It can be somewhat amorphous. What is the practice of law? We have 31 exceptions right now to the practice of law in our definition. So that's always an issue. Is this the practice, not the practice? It's right. Easier to identify when you're talking about something in court, because that's the practice. It's a little mushier when you're talking about some transactional things. And the truth is, until somebody brings it up and complains about it, then you'll probably, it's probably not going to be resolved. One of the things that we did put into our new rules actually is a more buoyant, I guess, unauthorized practice of law provision, because right now we really didn't have a seamless way of identifying it and doing anything about it. The only thing you could do is wait and ask a judge to say, this is the unauthorized practice of law. Now, judge will issue a contempt citation, and then you can enforce that later. We've changed those rules now so that our presiding disciplinary judge will now have authority to hear complaints about unauthorized practice of law and issue orders of stopping that. So along with all of this is a little bit more aggressive rules on unauthorized practice of law. We do have that. I'm sure every place has that issue, and particularly with our minority community here, with notarios from Mexico and such, we have that issue.
Some questions about newer members of the bar, and what do you say to them, and how can they innovate? What advice do you have for them about practicing into the future?
Well, gosh, new members of the bar, I guess it's no different than all of us. As soon as we get out, it's always changing, right? It's always something different. You're going to have your hills and your valleys, depending on what the economy is like. I think from what I've seen in the presentations for the last 8 years at least, I remember seeing this, how the practice has changed and is really going away from the traditional brick and mortar law firm and that kind of overhead to people that are being more innovative in their workplaces and their lifestyles. So I think my recommendation for people is to give some real thought behind that traditional practice that is all just burned into our mindset by watching movies or by going to law school and such, and think, what is your lifestyle like? So if you, for example, if you want to do more with your kids at home and more participatory, who's not really going to be able to go to work all the time, well, maybe you want to work for a place where you can work at home. I think everybody's seeing that now with the pandemic. That's maybe one of the few pluses out of this whole thing, is that innovation that would have taken us 10 years, we just did it, at least in the court system, the practice, and everywhere, in like 4 months. So we've seen what's possible, that kind of glimpse that you can see. Oh, can I construct my practice around my lifestyle, whatever that is? So I think I would encourage people to think a little bit more creatively before they embark upon their first step.
Do you think outside investment and the jobs that it might bring will come to Arizona as a result of you regulating these ABS entities to work with lawyers?
I don't know. I think that will be interesting. If I had to speculate, I would think that for both probably Arizona and Utah, that there will be a little bit of a wait and see. Let's see how this works. I've encouraged that in Utah, you've had people already, some of the, I think Rocket Lawyer, one of those that are, yeah, sure, let's try that out up there. If that works, sure, you will see more of that, I would think. And then very quickly, if there's success, other states will do it too, and follow along. My guess is that people that will take advantage of the new ABS rules initially will be traditional law firms. And so that they're the ones, and as I said, ethics lawyers around the state have said that they're getting, every day they get contacts from their law firm clients to say, what is this about? How can we take advantage of it? What can we do in the ins and outs? So I'm thinking that that's where you'll see some movement first. And then I'm hopeful, though, that people will move in with, especially with technology, to reach some of our distant counties. Arizona is a very rural state. And so the distances people don't realize, especially if they're back east, to get to the Navajo reservation is very difficult. It's easier to get to the Navajo reservation, I think, through Utah, go up to Salt Lake and drive down than it is just to drive from Phoenix. One of our largest counties, Mojave County, which is larger than most of the smaller states in the Northeast, has 6 attorneys who practice civil law. 6, that's it. So they're obviously hurting up there. And I'm hoping that not only the legal paraprofessionals, but maybe some creative folks can figure out a way to tap into that consumer client base in the rural areas.
When you regulate the ABSs, some of them might be using advanced forms of technology. Was there any consideration? Is there a scheme for evaluating or assessing the technology that the ABSs use?
Well, that's an interesting question. There's nothing specific to assessing technology. I suppose in their regulatory structure that they're identifying how they propose to operate, it might come in there. But again, we were, as I mentioned earlier, we didn't want to overregulate this. If you overregulate, people will say, well, why bother? I've already got my own, a lot of people, their own regulatory issues, if they're accountants or I don't know what happens with the FCC or something that might regulate some of the technology. So we tried to really shy away from that. But because you have to have approval from the court and you have to have reports then, I think once a year, and have your license has to be renewed once a year. So if there's issues, that would, I imagine, be the place where it would start to come out.
Well, thank you very much for that. Justice Timmer, thank you so much for the presentation. Delighted to hear what's going on in Arizona. Thanks for your leadership. And I wish you and your colleagues and the bar and the people of Arizona all the best in the future.
Thank you very much. I appreciate the time.
Thank you.
Have a good day.
Bye-bye. And we will just take about a minute to adjust things so that we can introduce our next speaker. And there he is, Crispin from England. Crispin Passmore has been in the middle of legal regulation for a long period of time and now has Passmore Consulting that advises governments, regulators, private entities, public entities throughout the world. Crispin's located in England. His favorite soccer team is Coventry, but we won't hold that against him. And Crispin, you've been in the heart of legal regulation and really the regulation revolution that's taken place in England for the past 15, 20 years, that revolution. You've been the executive director of the Solicitors Regulatory Authority, have been directors of various authorities which have been driving the agenda and driving things like the rules governing lawyer qualification, solicitor qualification in England, the direction of governments to implement change, and you've been able to be on the front lines to see and guide the implementation of that change. We're delighted to have you join us, and delighted to hear more about regulation. And maybe before you start any presentation, let me just ask you, we've heard in Arizona and Utah that the courts govern legal regulation. Who holds the pen in England?
That's a good question. It's a very different system. Regulation is controlled by our legislature. They have passed legislation over many decades that controls the practice of law and the regulation of solicitors, barristers, and other types of legal professionals. And they've put in place public bodies or bodies with public body style functions to do that work. And in the case of solicitors, it's the Law Society of England and Wales, but some particular obligations on them that they're not allowed to do it themselves. They have to create a regulatory body that's independent and beyond the reach of the professional body. So it's controlled by a legislature, and it's not an unauthorised practice of law regime. Most legal services can be delivered by anyone.
Well, that's interesting. So I didn't want to stop you from your presentation. Why don't you take it away and share your experience?
Okay, thank you very much. I'm going to share my screen if I can. And I'm going to hopefully start from the beginning. Okay. I think it's really important to just stop and ask why we regulate, first of all, and to think what the purpose of regulation is. It's not to protect lawyers. It's not to make sure that young lawyers have a future career or that their earnings expectations are met 20 years down the line. We, of course, regulate simply for public protection, public interest regulation. I think that really means two things. It means good enough access to good enough services, and that we make sure that the legal market and the legal profession protect the rule of law, given that underpins all of our economy and how it works. But when we let regulation stay in the hands of the profession of lawyers, we end up pursuing gold-plated standards under the banner of excellence, and we're told that that's in the public interest. It always amazes me that we don't ask more often just how lucky lawyers are that the public interest just happens to coincide with restricted access to the market, limited innovation, limited access for the poor and ordinary working people, and inflated profits that we do not see in the long run in other competitive markets. Of course, professional bodies do deliver reform. We've seen that across the world, and we've seen it in the UK over a long period of time. But it's usually a very gentle loosening of protectionist strings to deal with single issues, and very rarely is it a more comprehensive shift towards genuine public interest regulation. If I could see you all now, I'd say hands up if you think bankers should run financial services regulation. Hands up if you think drug companies should run the Drug Safety Agency in your jurisdiction. Of course, that's absurd, but this isn't new, this isn't modern thinking. This goes back 250 years to Adam Smith and the Wealth of Nations, and more recently to all sorts of different economists thinking about how regulation operates in markets. The really genuine change that happened in the UK from the Legal Services Act in 2007 was simply that the regulators were made at least partially independent from professional bodies, beyond the influence of the trade association or the trade union. And I think that independent regulation, often thought of as technical, often thought of as not the reform that leads to immediate change, but I would say it's the foundation of most of the change that has happened in England and Wales over the last 10 years or so. So what's the economic case for reform in England and Wales? Well, it goes back a long time, and it's based in competition. Still amazes me how many people think competition is a bad thing, yet still expect markets to innovate, prices to come down in real terms, and new products to emerge. This isn't about right-wing economics. This isn't some mad, over-liberal Englishman believing in free trade. This is simply about being in favour of choice in markets. For what it's worth, I'm actually a member of the UK Labour Party, which you would know if you follow me on Twitter, and I know Chris does, and probably laughs at some of my political thoughts. It's about just recognising really that we live in a market economy. We live in an economy based on businesses competing with each other. And being pro-competition isn't the same as being pro-business. I'm not pro any business. I don't care which businesses succeed in a competitive legal market, so long as the one that does isn't the one with control of the rules. It's the one that listens to customers, understands their needs, and finds new ways to meet them at ever better value. That to me is the difference between pro-competition and pro-business. What we saw in the UK is that weak professional services markets undermine the rest of the economy. Professional services for me are the oil that smooths the allocation of capital, the restructuring of businesses, the growth of new markets, the protection of people's rights at work, and the protection of their rights when they're dealing with public bodies. Professional services facilitate change, and without change in our economy, we're simply as poor and badly served by business as our predecessors and ancestors were 300 years ago. So this really is my access to justice slide. Let's just remember what the problem in the legal market really is. It's not poor quality lawyers, it's not unethical lawyers, and it's not that they're badly trained or not very good in court. Regulation around the world takes very limited amounts of action in terms of volume of cases against lawyers for unethical behaviour, because lawyers are largely very ethical and they do behave well. The big issue in the legal market is that the supply side of the legal market fails to meet the most basic needs of vast numbers of ordinary working and middle class people and small businesses, and it doesn't deliver value for money for corporate clients, let alone those people facing homelessness, mental health issues, domestic violence, discrimination, the sorts of numbers and people that Gillian was talking about earlier. If lawyers and regulators only care about the few that get access and make sure that they get good quality services, then over time, they become irrelevant to the vast majority of people. Unmet demand poisons sentiment and creates a world where politicians can attack lawyers and the judiciary for protecting rights because lawyers and the judiciary get seen as elite and out of touch. To me, the rule of law demands access to justice and an open legal market. Just want to remind people how long reform takes, for those of you that are ambitious for reform in your home jurisdiction. We've gone through a long period of time to get the sorts of change that we've seen in England. And that's from a very different starting point. We don't have an unauthorised practice of law regime. It took 10 years from the original report on competition in professions through to the first ABSs. And it had several stages of reform that you can see on the slides. And that's really because of the vested interests that fought every single step of the way. The number of lawyers in our parliaments, the power of the lobby of large law, the power of lobby of our law society, slow down change at every stage. And it wasn't really until independent regulation came from the Legal Services Act, really took effect in 2009 and 10, that we started to see an increase in the pace of change here in England and Wales. So what does an independent regulator look like in action? Well, I think it took a few years for the SRA post-2007 and the implementation of those reforms to get to the independence needed in its culture, so even after it was first created. And I think that independence of culture is really important. I'd encourage all of you to read the Decker and Yarrow paper mentioned on the screen, Understanding the Economic Rationale for Regulating Legal Services, because that underpinned much of the thinking that led to our reforms here. How could we strip away economic rules and maintain and strengthen ethical rules? I think by 2014, the SRA was confident enough to say publicly that it would remove regulation that could not be justified. That is a really significant turnaround from the way that legal regulators and other regulators often work. The normal approach is to say, let's consider reform, and if we can prove it's safe, if we can put in place tight controls to restrict any potential harms, then we'll carefully consider loosening the protection strings just a little. But to take the bold step of saying we will remove any regulation that we can't prove with evidence is required against our objective of public interest regulation was a really bold and significant step. The reforms, I think, speak for themselves. The SRA really welcomed the continued support of competition authorities across the legal market. So even as reform was going on, our competition authorities were continuing to come and look at the legal market, demand further change, highlight areas that they could draw on experience and expertise from looking at other markets in detail, and provide the support to the regulator to face down vested interests that were trying to prevent further change. The Competition and Markets Authority, the CMA, is currently looking again to refresh its work back in 2016, and probably before Christmas, we will see further proposals from them to push for further reform. And in the last few days, we've seen the Solicitors Regulation Authority publish its submission to the CMA, talking about the next round of reform. Again, another round of bold reform to liberalise the legal market, and particularly the legal labour market. So what are the key reforms? Well, they speak for themselves in many ways. Rolling back the sort of regime similar to the unauthorised practice of law, allowing alternative business structures, multidisciplinary practices, getting rid of bans on fee sharing, allowing solicitors to practice in businesses with no regulation of the business, no ability to deliver the highest reserved activities, just able to work in an unregulated business, delivering low-level legal services that simply don't get delivered in most jurisdictions. And really significant reforms as to how solicitors qualify have just been finally approved in the last couple of days. Those reforms are technical often. They're not just the big reforms about allowing non-lawyer ownership. They're also about removing small and technical rules that get in the way of particular forms of innovation. And the SRA has reduced the rule book from 2014, it was in total about 650 pages, down to what it is now of 100 pages, which the core for lawyers is a 7-page code of conduct for individual solicitors and a 7-page code of conduct for regulated firms. But I want to really just stress that whether we regulate or not, change is already happening, reform is already here. It seems to me that we just have to recognise that the debate about reform is not one of whether we allow change to happen. It's already happened in the UK and it's already happening in your jurisdiction. The nature of demand has changed. Consumer and competition law have grown so that sector regulation adds less than it did 30 or 40 years ago. And we've seen the legal market break into more segments where they behave differently in different areas. And some of the cross-border pressures that we've seen have again led to change in the legal market. I think I could mention businesses across most of the world, even in places like many of the US states that still operate with an unauthorised practice of law regime, where we see Rocket Lawyer and LegalZoom, we see Axiom, United Lex, we see the big 4 professional services firms, all in there, all delivering despite the unauthorised practice of law regime. If you build ever higher walls around a market, you simply become less relevant and capital will flow where it needs to flow. Customers will buy services that they want, even if they're not on offer through the regulated market. Axiom is nearly 20 years old. It might not be delivering legal services, but it's delivering something that meets the legal service needs of its clients. So this really is about keeping up with the change that's already happening rather than pretending that it's regulators that drive it. We could go through pretty much all of the legal market and talk about any particular segment and point to firms that are doing things differently in the UK and often elsewhere in the world. They're delivering will writing services. They're delivering legal services for small businesses. They're delivering online and tech businesses, outsourcing businesses, multidisciplinary practices, online app-based resources for dealing with divorce law. There really is not a part of the legal market that is not being touched by the radical reform that England and Wales have seen in the last 10 years. Still, traditional law firms make up the majority of the legal market, but their significance is shrinking. Roughly half of new firms that are authorised each year are ABSs, and around 1 in 9 of all of the law firms in England and Wales now have some form of non-lawyer ownership. And that includes businesses floated on the stock market with private equity and venture capital behind them, as well as the more traditional firms that have taken a husband or wife into partnership for tax reasons or something similar to that. But the change really is happening, and it's happening across the piece. I want to talk about some of the impacts of these changes. It's still early for evaluation. Reforms takes years to have real impact. I always remember that Amazon is now more than 25 years old, and we think it's a new business having new effects every day. Yet we expect the legal market to change, a more conservative market to change overnight when reform happens. But we can see the early signs that lead to long-term change in the legal market here in England and Wales. So we can see innovation across the piece, more frequent and more significant in ABSs than in traditional law firms. Whether we look at service innovation, delivery innovation, organisational innovation, it happens more in ABSs. That's not really a surprise if we think that these are people that have not just risen to the top of a law firm because they started at the bottom and there was nowhere else to go. These are people that have chosen to deploy capital to invest in the legal market because they thought they had something to offer. Or they're traditional law firms that have brought expertise in from outside of the legal market with lateral hires on technology, marketing, or the expertise that often comes alongside financial investment from private equity or the stock market, etc. So it's no surprise that ABSs innovate more. But it's not just innovation that we can see as being a significant benefit from non-lawyer ownership and these other reforms. Independent evaluation of the reforms in England and Wales, which has started but will carry on over the next 5 or 10 years by the SRA and making data available for others to do research. That independent evaluation shows that more work is being done in different ways. It goes beyond innovation, capital structure, the long-term view and capability to think long-term. To me, these sorts of things, this long-term strategic thinking that underpins innovation comes from more investment and non-lawyer ownership. It's like the difference between a local taxi firm and Uber. Both are important, both are good, both are valid ways of practicing, but a taxi firm is thinking about its revenue and its profits this month and this year, whereas Uber is thinking about a 10, 20-year program to try and become bigger, grow its value, and grow its resonance with consumers in any way that consumers would value from it. And that's what drives it up the value chain. And it's important to talk about the value chain. One of the things we've really seen here in England and Wales is businesses that entered as an unregulated space, filling gaps that law firms were unable to fill, gradually have moved in to deliver some more lawyer-led services and are moving up the value chain, buying law firms, developing their own law firms, and moving up to compete. And I think over the next 2 or 3 years, we'll see some really significant investment that really sees that external ownership drive right to the very top of the legal market here in England and Wales. Other research has shown that it's not just innovation. Actually, it's also that non-lawyers within law firms tend to lead to better complaints handling. Isn't that interesting? This isn't just about sexy innovation. So much for non-lawyers lacking ethics, they lead to law firms being better at protecting the public and dealing with public unhappiness about their services. I think that should be really significantly noted. And of course, it's not just in the UK, the impacts are international. The benefits of reform are attracting foreign investment into the UK. We're seeing stuff from the United States and elsewhere around the world, both in terms of law firms and capital into UK law firms that expand with private investment through the stock market or through private equity. And of course, major legal businesses from the US like LegalZoom and Rocket Lawyer able to operate in the UK in a way that they cannot in their home country, which is good for the UK, but seems slightly absurd for California, their home states. In particular, it seems to me bizarre that a company like Rocket Lawyer, with something like 20 to 25 million US adults have an account with them, delivering things that look quite a lot like legal services, and not able to go to the next step, despite, as Justice Timmer said earlier, having really clear insights about the problems that clients face, and the customers are dealing with problems on their own. They're a solution to the problems that customers face in a way that law firms simply are not set up to be. Law firms, as we see again and again, are really good at dealing with corporate work, court work, expensive work, but they're not able to deliver a cost-efficient way of resolving the ordinary life problems of individual citizens and small businesses. So in all of this, what about the lawyers and law firms? Well, this week, England and Wales tripped over 200,000 lawyers, solicitors for the first time. The number of solicitors has grown each year uninterrupted since at least 1960. It grew through the oil shock of the early 70s. It grew through the economic collapse in the early 80s. It grew through the dot-com crash and the global financial crisis, and it's growing through the pandemic. The number of lawyers grows as we liberalise the market and provide more opportunities for lawyers to offer their ethical expertise to customers of different sorts. So I'd finish by just saying, let's have some confidence. Let's get rid of protectionist thinking, open our minds to reform, and grow this market so that it becomes accessible and relevant to ordinary people. Thank you very much.
Well, thank you very much, Crispin. That was energizing, great insights. And no, I quite agree with a lot of what you write on Twitter. There are similarities among political views that are called different things in different places. I'd like to start maybe with the new entrants to the bar. You've made the point that so many more lawyers, solicitors are joining every single year. You've had a big hand in changing the licensing process. What did you do and why?
There's two stages to this. The first stage is to change the licensing process simply so these people can apply. Reform the rules so that it's legal within the rules to have non-lawyer ownership. But I think that's only step one. And it was really heartening to hear Justice Timmer talk about the risks when you liberalise a market of over-engineering the mitigations against problems that lawyers tell you will exist. It's really easy to design a licensing regime where you tear up 5.4 in the US, the fee sharing ban, but then you put so many restraints around an ABS that those firms look at it, shrug their shoulders and walk away because the costs of regulation are really so significant. And I think we got that wrong in the UK at first. So from our first ABSs in 2011 through until probably 2014 or so, we were taking too long. We were taking a year to authorise an ABS. We'd look at every single investor within the ownership structure individually. We'd look at every partner in a professional service firm. We'd look at the partner in Colombia that didn't even know England existed, let alone that their firm practiced there, let alone that they wanted to be regulated to deliver legal services. We got rid of that and we sped up the process. And by the end of 2014, we were taking about 6 weeks to authorise a new business. That's the sort of business-focused regulation where you start to understand how these businesses operate and what really are the risks and what tools have I got to deal with it after I've licensed them if problems manifest, rather than think that you can right a rule. In the end, regulators are like surgeons. If they think cutting you open is an answer to everything, and regulators think writing a rule is the answer to everything. And you've got a much bigger toolkit as a regulator.
When you approach the ABS issue, and if Ontario was to open up its rules and allow alternate business structures, What do you think the government should focus on? And what do you think it should not focus on?
I don't think government should try and write rules, and I don't think that it should try and design outcomes in detail. I think it should probably do a couple of things. It won't surprise you, I think the first thing they should do is create an independent regulator. You separate the regulator from professional day-to-day influence. Doesn't mean professionals shouldn't be involved, but you separate it from their control. And you give it clear statutory objectives around public interest regulation, promoting competition, promoting the rule of law, promoting consumer interest. You might want to add in an objective around a strong and diverse legal profession. You know, that's a matter of choice. But I think strong objectives for an independent regulator is a really important first step, because that changes the culture. Boards come together, and even the lawyers that we saw on our board, it only took them 1 or 2 meetings before they started to think like a regulator rather than like a trade union official. And that was always really heartening, because they're bright people.
When you set up that independent regulator, you still got the body that regulates all the lawyers. In your case, the solicitors. First of all, how did they react when the change happened?
So when we set up an independent regulator, we took over all of that regulation. So we took over the regulation of solicitors and their rule book. The legislation required the Law Society, in effect, to put beyond its reach anything to do with the regulation of solicitors and the legal market. So you don't just have a regulator for the independent bodies, you're regulating everything about solicitors within that independent regulator.
And there is a body now that represents lawyers themselves.
Yes, and they're my best friends, perhaps. I think law societies just need to focus on representing their members and recognising that their members have diverse interests that flow from diverse aspirations and diverse practices. And if they recognise that variety, they would be less likely to slip into thinking they need to protect any particular model of practice or any particular form of practice. But we've still got challenges of that here. So our law society is still able to tax the legal profession £30 million a year through the practice certificate to fund its trade association work. Yeah, that surprises most of us.
Have you noticed a change or an evolution of thinking in those who represent lawyers, solicitors?
Yeah, definitely. And I think, my experience of going around the country talking to local law societies and senior people in law firms is that most of them are now look at reform and shrug their shoulders and just say, this is the world I now operate in. It hasn't caused problems. It's more things for me to think about, which I think is a good thing because they're having to think about their business and how to succeed. But they tend to be much more positive about these reforms than they used to be. The Law Society, I think, is torn. I think there's a cohort within it that wants to go backwards. But I think that increasingly the leadership of the Law Society recognises that the world has changed, lawyers are a diverse bunch working in different ways, and they need to embrace that and be more positive about the opportunities for the legal market.
You pointed to research that suggests that ABS bodies with non-lawyer participants are at least as ethical as lawyer groups. That might be a little bit of an edgy comment for many of the lawyers listening. What about consumer satisfaction, client satisfaction? Do they like the ABSs or the non-lawyer driven entities as much?
I think the reality is that ownership is broadly irrelevant to any meaningful analysis of the legal market here. What really counts on the discipline side is, are you doing work that's high risk? Are you involved in handling client money? Are you involved in asylum work? There's a whole bunch of risk factors, and it's those that drive unethical practice, not the ownership structure. And then on the customer side, it's whether or not the customer is getting what they thought they were buying and what they chose, rather than who owns it and that sort of thing. But what we do see, I think, is that growth in markets is coming from businesses that are able to invest in technology and new ways of delivering, be that writing your will online or dealing with a personal injury claim online, or at the other end of the market, flexible lawyer platforms and managed legal services and outsourced services delivered by some of the alternative providers. It's the service and its focus on the customer that drives customer satisfaction, not the ownership structure.
Has there been more choice for consumers in these different areas since reform has accelerated?
Yeah, without doubt. And consumers are beginning to shop around more. We see we have something called a consumer panel, which is a panel put in place by our oversight regulator, statutory panel, that's there to represent the interests of consumers into the regulator's thinking. It does research on a regular basis on a whole bunch of things, independent research run by YouGov usually. That shows customers are increasingly shopping around and increasingly satisfied with the choices that are available. And we're seeing some changes in pricing within the legal market as well. Not simply lower prices, but probably the reduction of price, what we call price dispersion. So, yeah, in a competitive market, you just don't survive if you're twice the price of everyone else. What we're seeing is that in the legal market, you have been able to survive, but over time, the increased focus on client acquisition and use of technology and the internet and the such is beginning to tackle that. So customers are getting more choice and getting a better deal, but it's marginal, it's gradual, it'll take another 20 years.
So one of the questions we have is, so the big can get bigger without limitation. And I know early on there was concern in Ontario among some trial lawyers about a big entity coming in and buying up all the insurance firms. And is that an issue? Is it a concern or?
So, you know, I guess I see this the same as every other market really, which is that of course, too much concentration is a bad thing. You know, as I put on one of the slides, why competition? Well, because otherwise monopoly. And monopoly is not that attractive an idea, whether it's a lawyer monopoly or a single business monopoly. I think we have good tools for managing that across our economy. We have strong competition laws and we have a strong competition authority to handle that sort of issue. And regulators need to have rules not just on ethics, but I think if you have restricted access to a market, which is what we rightly have in any way, that's what a licensing regime is for individuals and businesses, you've got to also have one eye to pro-competition regulation within that as well. So I think you can regulate to protect against that. But what we've seen in the UK is that there's been probably a 40 or a 50-year very slow concentration of the legal market, the gradual reduction in the number of solo and two-partner firms, but that hasn't sped up because of ABS, and the big firms haven't pulled away faster. What we've seen is a gradual concentration. I think the nature of delivering excellence has meant that solo practice is less tenable than it used to be for a lot of people. So I just don't think the evidence supports that would happen.
But at the same time as you've been opening up the legal market in England and Wales, we've had this technology evolution/revolution and the capability of technology in law or elsewhere. How has that advanced innovation? How has it challenged it? What's been its effect combined with ABS?
So I think the legal market's slow on tech, isn't it? What one of the competition experts I know that talks about this says, you can just test competition and the quality of competition in the market just by looking at the adoption of technology. If there's not high adoption of technology, it's not a competitive market. I think we're seeing an acceleration from a very low base on the use of technology here. We're seeing law firms think about data as a resource and that being then used through technology to deliver better services. We're seeing them do some of that themselves, but we're also, I think, seeing a gradual recognition that they don't have the sort of the capital structure and the corporate structure to do long-term investment. The nature of partnerships is they distribute their profits, and the nature of the new entrants is they're building capital value for long-term growth. So, the latter is better able to invest in tech. We're seeing more tech emerge that services law firms. That's had an acceleration during the pandemic. I think of a little business called Legal that provides client onboarding services and client payment services. That's sped up. Regulation can get in the way of that by having restrictive rules. We've tackled some of that in some of the micro rule changes and rule deletions that we did. But I think regulators have also got a role to try and change culture as well. And that's a really interesting thing. It's not enough just to tear up the rules. You've got to try and give the market generally confidence to invest and confidence that they're allowed to do stuff. Lawyers brought up waiting for permission are frozen in the headlights when you take away the requirement for permission. They don't go out and actively do stuff. They just, they're like little rabbits. Poor little things, I often think. So you've got to try and change the culture and encourage lawyers to partner with people that will help them innovate. In the end, all of this is cultural change. It's not rule change.
Culture change is the hardest.
Yeah.
Change to make. It really is the hardest. One of our questioners has asked about customer choice. Customer choice is a good thing. Customer confusion, not so much. And this is an issue in Ontario where we don't have a deregulated market. We have a highly monopolistic one. How do people find out about the choices they have once they have choices?
Yeah, I think it's interesting, isn't it? I think even before reform, people were saying customers are confused, they don't know where to go. I think it's more nuanced than that. I think that customers with serious issues do navigate legal markets and they find their way not just to lawyers as opposed to unregulated people here, but they find themselves to lawyers in their practice area and lawyers that are expert and affordable for them in that, whether that's legal aid or private and expensive. So, customers are better able to navigate than we often expect. The internet is good at that, but we have limited use of what we would call digital choice tools in the legal market that are prevalent across many other professional services and retail services. That is almost certainly something that our Competition and Markets Authority will have something to say about before Christmas. My submission to them is that we should require our regulator, we should require the SRA to set up a embryonic digital choice tool, a comparison site for legal services.
You mean like TripAdvisor for lawyers?
Well, we have tools where compare the market and things like that, where you buy your insurance on an insurance aggregator. They're not problem-free as tools. They need careful thinking themselves, but they give customers a good way to see the choice and standardize pricing in order to then go and have one-to-one conversations with firms as well as buying separately. Most lawyers are horrified at the idea.
I was about to say the same thing.
Well, we took the first step 3 years ago where we required lawyers to publish standardized pricing across several areas on their websites. Enforcement is just beginning on that. Again, you can imagine how popular that was. But what it's led to is a reduction in price dispersion. People that were hugely expensive can no longer hide that price dispersion. How hard is it to find out the price of a divorce? Well, nobody will tell you over the phone. They'll offer you a free 30 minutes interview, very generously, of course. And at the end of the 30 minutes, they'll make your next appointment and they might tell you a guide of a price or how they're going to calculate it, but it'll be a lot more than that. Do you really expect customers to do that 5 times to get 5 different prices? Putting transparency on prices is in the end what really drives competition and shopping around.
Yeah, that's interesting. What's the next step in England and Wales for regulation? or deregulation or competition and choice in legal services? You mentioned this price comparison. Where do you go next?
So I think there's other elements to change. If you really want to change the legal markets, it's not enough just to talk about ownership structures. You have to also think about how you regulate and keep eroding rules that have unintended consequences of being bad for competition, or rules that you put in place that restrict but don't appear actually to end up having the benefits you thought they would. So you've got to be just, there's not a magic wand you wave. You just got to keep challenging the rule book to take stuff away and to sometimes add new stuff that supports customers and competition. But I think it's not just ownership and where you regulate. I think you've got to liberalize the legal labor market as well. So you've got to get away from expensive routes to qualify that are high risk, that lead to dissatisfaction amongst students, that lead to, in the end, not enough lawyers for the amount of demand that really exists out there. There might be too many students for the number of training contracts, but not enough for the amount of demand. So you've got to liberalise the labour market. And I think the SRA will do that through the new education qualification route that comes in next year, but also by moving away from just having you must be an expert in all law to become a solicitor. Could you become a solicitor that just does real estate or just does personal injury? So there's sort of limited license approaches as well. So there's lots of changes like that.
And you've been involved in some changes for the qualification of solicitors rules and what's the goal of those rules? I think the first exam is to be sat next year? Next
September, yeah. So this it got its final stage of approval yesterday. This is called the Solicitors Qualifying Exam. It's 6 years in the making. It's a once every couple of generation reform of how solicitors qualify. And it's a really radical move away from time served and proof that you studied a bunch of subjects to say, can you pass assessments to show you're good enough? Yeah. Assessments are a mixture of knowledge, but probably more importantly, skills and behaviours. Because of course, the knowledge you test will have changed 2 years later. So it's, can you handle knowledge and can you show you can learn rather than can you recite law? And then skills and behaviours about your ability to interview a client, your ability to do oral persuasion, your ability to do legal research, and they will be done in day and 2 day tests, assessments that involve actors and lawyers, sort of situations that are created for people. Much the same as we're moving to for our medical profession here, where GPs are general practitioners, sort of high street doctors, go through similar sorts of assessments already. And that gets away from saying, we need to measure your inputs. I don't care how many driving lessons you had. I don't care whether you read the highway code or you read the rules or not. I care whether you can drive. I'm interested in your ability to drive, not who you did your driving lessons with.
Sounds a bit like our law practice program training that I run when I wear my other hat. I wanted to ask you two things. First, you spoke about standard pricing, transparency on pricing. The age-old question, well, what if my client is difficult or it's an emotional case or there's a twist in the road? How does standard form pricing work?
So I think what we expect is for people to say, this is the typical pricing, and these are the factors that make it more expensive, and these are the factors that might make it less expensive. Our bank said all the same about the interest rates they charged on credit cards, and they used to advertise one rate and then charge everybody a much higher rate. They were forced over time to say this is the typical rate, and they could tell people if they wanted to, these factors will push the rate up and these factors will push the rate down. So we can do the same. It might not apply to all legal services, but it ought to be able to apply to buying and selling a house, writing a will, doing a basic divorce. And increasingly we're seeing some law firms embrace that and recognise this is a real opportunity. If you can say we are good value, it's not about the lowest price, it's about good value. We're lawyers, we're experienced, we're expert, we'll share some of the risk with you. We'll do you a fixed price. We have a big enough volume of cases and a good enough understanding of the drivers that we can give you a fixed price because we can absorb risk. Lawyers that tell me, well, every price is bespoke, I don't really buy it. It isn't the reality, particularly if we were to analyse their files, and it's always more expensive than they quoted at the start.
Last question, as we run out of time, let me end where we began. The reforms were very much driven by a Tory government in England and Wales. There are governments of different stripes. Is there broad party support for opening up the legal market?
Yeah, our first reforms, the reforms have actually happened over 30 or 40 years. So we had the introduction of some limited license practices versions under Margaret Thatcher, a very conservative government of the 80s and early 90s. The Legal Services Act was started by a Labour administration, but it went through our Parliament in a joint committee where the chair of the joint committee was a Conservative peer and a Conservative senior partner of a major law firm. And it has continued with broad cross-party support ever since. The outlawyers, perhaps there's a Freudian new word I've created here. The outliers, I think, are the lawyers that look backwards, not lawyers in general, because all sorts of lawyers have embraced reform and taken opportunity.
So governments are siding with the people over the lawyers.
Who'd have known it?
How interesting. Crispin, thank you so much. Thanks for taking the time. Really appreciate your insights. This has been fantastic.
Thank you very much for having me. Thank you.
Yeah, so just a reminder, we're going to take the next 15-minute breaks. We'll be back at 3 o'clock with Andrew. Thanks, everyone.
% of your team's time goes to doing things that aren't actually work. Asana gives you that time back. Assign tasks, select due dates, and keep everyone on the same page. You can find the latest and greatest attached to each task. Discuss work details right where work happens. With Asana, your team can view any project in the way they find most useful. They can avoid getting overwhelmed by balancing their workload and removing bottlenecks. With Asana, you can see what everyone is doing and automate processes for the type of work you do most often. And it provides built-in feedback and approvals to keep things moving. Asana is built to scale across your entire company, so anyone can see where things are at and how it all maps back to the company goals. So get that time back and get the team organized around the work that matters most. Try Asana today.
if you're not using RIGE for project management and team collaboration.
If you're tired of reading about other people getting rich in the stock market, this might be a good day for you.
The gremlins have been eating the wires. So Hirsch is just figuring out the sound issue, which was working perfectly before, but has not managed to work at the moment. Hirsch can hear me, but I can't hear Hirsch.
Can you hear?
Yes, perfect.
It works? Okay. Beautiful. Okay. Sorry about that. Okay. Andrew, you're good to go off video?
I am. You just have to enable me to do so.
Yeah, beautiful. Okay.
Good
So
to go.
perfect. There you go. Okay. It is, as always, my absolute great pleasure to introduce and have a conversation with the Legal Innovation Zone's very good friend, Andrew Arruda. For those of you that don't know Andrew, he is a Canadian entrepreneur and attorney. He is the CEO and co-founder of, I would say, probably the best well-known artificial intelligence legal tech company, Ross Intelligence. He speaks internationally on all subjects, obviously, including AI, legal technology, entrepreneurship, and also access to justice. He has been featured in newspapers, magazines around the world. If you haven't caught his 2016 TED Talk, you should. 30 under 30 a few years ago, and really everything in between. I'd also point out he serves on the board of the Institute for the Advancement of the American Legal System, as well as serves on the subcommittee. He is the subcommittee chair of the Alternative Business Services and Multidisciplinary Practices Subcommittee of the State Bar of California's Task Force on Access Through Innovation and Legal Services. Welcome, Andrew.
Great to be in conversation, and in particular on a wonderful day that has featured so many amazing speakers, and I've just been following along, enjoying every second, and certainly have some thoughts to share and looking forward to it.
Perfect. Yeah, it's again great to have you. I thought maybe I would start off with the last point of how I introduced you about the task force that you've been very involved with in California, and we've heard from a few justices about what they've been doing, and so I thought maybe you'd maybe let us know what you've been up to and what California has been up to, or with some of those subcommittees.
Absolutely. So my position over with ATILS is now up as we've kind of concluded our initial work. We recommended a variety of different changes to the powers that be. And as for everyone, just I get this question a lot: what's next in California? Right now, there are two main action items that have come out of the work of ATILS. One, which is the creation of a paraprofessional working group, which is looking at the expansion of the paraprofessional program in California. Oftentimes, when you think of us expanding who can deliver legal services, we sometimes forget that we do have programs for paralegals and paraprofessionals. So it did seem like a no-brainer to the group and at ATILS to consider expanding that, having those educational programs in the colleges that are already administering those educational courses and administering and regulating those folks, be able to be part of the coming changes in the regulatory shifts that we're seeing. The other aspect of what we're up to is the creation of a group that is going to be looking at and creating what the outline of a sandbox approach would look like in California. Earlier today, you heard from Justice Himonas about what's happening in Utah. You also saw just not too long ago from Justin Timmer, kind of skipping over some of the steps with the sandbox and going into a straight removal of 5.4, which I thought was a fabulous move by Arizona. I think the big thing about California is it's a big state. The population size is large. We have a huge practicing population of attorneys. And so we, I think, are making fabulous progress, and it's been really a breakthrough year. The concrete steps coming out of the work of ATILS and these other working groups is set for 2021, which at first always seems very far away, but then I remind myself we're almost to November. So it seems far, but it's coming up. So we're continuing to make progress there. You're going to hear more from the California State Bar. And I think it was a pretty banner year in terms of re-regulation in the state of California.
Great, thanks. And so you mentioned Justice Himonas and Timmer, and we obviously just heard from Crispin. And so there are a lot of different ways that you can take sort of these paths. And you mentioned that in California, they're going along the sandbox. What else would you recommend they try and achieve, and what types of incentives do you think they need to achieve better access to justice? Well,
I mean, the name of this conversation that we're having is really kind of how can the entrepreneur help? And I think ultimately when I thought about what was going on, I hopped in. I was a lawyer. Luckily, I met such a fabulous computer scientist, my co-founder Jimo Viagle, and was able to co-found Ross. But I think that, in my mind, there was this obsession with, if we create the best tech tools, access to justice and better access to legal services will flow. That was kind of my first initial thoughts of, what I was setting out to do with the team. And I think I learned pretty quickly that wasn't the only kind of spoke on the wheel that needed to kind of be adjusted. And in my mind, I think what you really need to have a fertile ground for entrepreneurship, for innovation within legal service delivery, is kind of four things. There's many things, but I'm going to boil them down. So one is you need a regulatory framework that enables and allows for it. At the basics, it allows for it. ideally it promotes it. So right now, as you can see, we're at a stage, depending on where you are, where we're seeing that occur. And I think that that's without proper regulatory framework, it's dead in the water, innovation in law. And I think that's why we've been seeing such slow innovation to date. The other thing that we're going to need, and you see a lot of, is the need for subject matter expertise. And so right now, when you think of legal tech, you go in and you go onto Twitter and you see that hashtag and you see the folks who are involved in that. Isn't it interesting that in areas like fintech, in areas like medtech, the founders and entrepreneurs in that space are not always former doctors or folks who had a financial background. However, when you look at legal tech and you look at legal technology, almost all of the founders in the space have a legal background in one way, shape, or form. And I think that is a good thing because you have that legal expertise, but I also think it's a negative. And I'd love to see a world where we enable individuals who have the expertise in technology services delivery and folks who come with a fresh new perspective from the mind of a consumer of legal technology can get involved. So that's that's a key thing. The other two areas I think are going to be funding. Funding has been tough to get in the space because of that number one issue, which is that there wasn't a regulatory area that enabled this. So a lot of venture capitalists didn't want to jump in. But the other thing that I think folks forget about entrepreneurship in our space, is sweat equity. Is the idea that it's not just about dollars and cents. The regulatory shifts you're seeing in Utah, the regulatory shifts you're seeing in Arizona and California and in other states coming in the horizon is also about enabling two individuals. One may have a legal background, one may not, to be able to start a law firm, a legal services delivery, an app, and share in the profits. They're going to share the risk, they're going to share in the losses, and they can share in the upside as well. And that's key. And the last one, and the fourth thing that I think is essential, is community. I think that is going to take time to develop. You heard from Crispin just before me that a lot of the rules and the changes in England took about 30 years. The shifts that you're seeing in Utah and in Arizona and California did not happen overnight. And so I do think that sometimes we get into this feeling where all we have to do is change the regulations and everything else will be ideal. And so I guess I think sometimes as an entrepreneur in the space who is kind of seeing these different spokes, I like to remind people this isn't Field of Dreams. If you build it, they won't necessarily come. You do have to have and be thoughtful about how to, after the regulations are changed, enable and have a fertile area for that entrepreneurship.
As you know, we run a bunch of startup programs, and I always have in my slides a picture of the cornfields, and obviously always use that line that if you build it, it does not come. I was actually going to jump into community, so I'm happy you mentioned that. I'm just going to remind everyone, if they have questions, please send them in, and we'll try and get to as many as possible. Community is so important to everything that we do at the Legal Innovation Zone. You have been an absolute leader when it comes to the startup world. I mean, you speak for us all the time, and I know you speak all over the world to lots of different startups. I wonder, are there any lessons learned of startups that are looking to make a difference in the access to justice space? Any 2 or 3 pieces of advice that you'd give them from mistakes that maybe you made in the past that maybe they can try and avoid?
Well, I would say just as a general statement, and then I'll go to the specific. I think as a general statement, similar to what you see with very kind of positive thinking folks in law school who are trying to make a difference with access to justice, there are a lot of realities once you get out of law school to actually trying to work in the field of access to justice. You're saddled with debt, you can't pay rent, it becomes very difficult. And so I do think that there's a similar challenge when it comes to access to justice, legal innovation. Because if your app is free and you're trying to get attention, you do need marketing dollars. Everything costs money. And again, that analogy that phrase that I use quite often around, if you build it, it doesn't mean necessarily they'll come, I think applies quite nicely to innovation within access to justice as well. And that's why I think you have to attack things on all of the different quadrants that I had mentioned, where you need that regulatory kind of framework. But I think my advice directly, and now to move to the specific, would be to ensure that you rethink the term access to justice to begin with. Oftentimes when folks hear access to justice, they think of only one subgroup in terms of socioeconomic status of delivery of legal services. To me, LegalZoom is access to justice. To me, large law firms in the AmLaw are delivering justice as well. I think it's expensive and overpriced, a lot of issues with that. But my point is, I think when you look at justice holistically and think about how everyone needs access to legal services, you can do good, form a business that it's profitable and can pay your employees the money that they rightfully deserve, and yourself, and make a living out of it. So I always encourage folks to say there's nothing wrong with, when you're forming your business idea, to also think about how are you going to sell your product, who's going to purchase it, and to not just get wrapped up in just solely the impact you can have from kind of a lower socioeconomic status community. I think the same tool can be sold across multiple income gaps. And you see that with some of the amazing work in areas like divorce apps, will apps, et cetera, the same price. And what we're doing at Ross, we believe that the same, a lawyer, attorney, a paralegal, at a large law firm, at a small law firm, should be priced the same and get the same service. And I think the same thing would apply to any new app in the space.
That's great. And we obviously couldn't agree more about the term of access to justice and who it affects. And Chris, I think, has mentioned it a few times, and everyone else, many others today, talking about, you know, the 9 in 10 businesses that can't gain access to contracts and all that through a lawyer. So for sure, access to justice is no longer that traditional access to justice, and that gap has definitely been growing over the past number of decades.
And Hirsch, yeah. I'll say this. I also think that sometimes folks who are trying not necessarily to enable innovation in the space will use access to justice and the term of it as a weapon. So what they'll say is, well, how does this prove to me that this is going to help this group of individuals? Where the interesting thing is that I think of our current delivery of legal services, and it's a result of the regulatory framework we have. There's a banquet going on. People are engorging themselves in a hall. There's more food than anyone could ask for. It's just you know, desserts and everything's coming in that door. And in the next room, people are starving. And the problem is when you have a system that 80 to 90% of individuals can't afford legal services, it's criminal. And so I think when someone says, prove to me you're going to help, a lot of the time it reeks to me of protectionism, and it reeks to me of someone who is actually trying to use that as a mechanism to argue against change coming.
Yeah, I want to take this in so many different ways. I'm going to stick with the entrepreneurs for a second, then we're going to get back to regulation. For the entrepreneurs, I'm wondering if there are any 1 or 2 areas that you believe are ripe for innovation that you think some entrepreneurs should be focusing on. And part 2 of that question would be, lots of people think AI is sort of off in the future and people aren't actually using it. And I was wondering maybe if you could comment what role you think AI plays in access to justice.
So I would encourage entrepreneurs to really consider Utah's sandbox, as well as the framework in Arizona. I think going in the path of least resistance is a smart idea. In particular, both of those states, and I think it's not a surprise, do have active tech communities. You look at Utah, they have Silicon Slopes, which is a fabulous name for any tech community. And so you see this understanding through government, through all areas of society where, oh, you know, I understand the power of technology. And in Arizona, I would say something is equally amazing happening. Phoenix has a very large tech scene. And Tucson, Arizona is an area that increasingly is really surprising me in terms of the quality of the talent and companies coming out of there. So what I would say is, if you're interested, I think starting in these spaces is a really great idea. The populations in those states are not the largest, and I think that's a really great test bed for some of your ideas in scaling. The second part of your question was really, I think we are in a world where technology and law is occurring quite rapidly. I think, unfortunately, we had to have a global pandemic to prove that you could accept a digital signature. I repeat, a global pandemic was needed to enable this rush of individuals being able to accept a digital signature. That is insane. That being said, I'll take the wins. So here we are. And I think as an innovator, I think areas that previously were the areas of a video game map that you couldn't see or enter are opening up. And so there is a lot of opportunity. So I would really, if I were an entrepreneur looking to start up a new company in the space, I would start to talk to small business owners. I would start to have something that not only can adjust to this new reality we're living in with COVID, but also fits in a post kind of COVID vaccinated world as well. So I think there are ideas that can be boosted a little bit initially by some of the push you're seeing due to the pandemic. But I do think you don't want to be a pandemic focused company solely, because that's a tough spot to be in. And there are plenty of ideas, landlord tenant issues, family law, that I think there is a great necessity for innovation there, and a great way to have some boost in some ways from this pretty unprecedented times we're living in.
And just to bring it a little bit into the AI world, which you are an absolute expert in, what about, what do you say to people who are afraid that, we're just handing things over for computers to make decisions, and how can we trust computers and built-in biases and stuff like that? What's your comment to that stuff?
Well, first, thanks, because you very gracefully reminded me that I didn't answer the question about, is AI kind of futuristic and what it does for A to J. I think artificial intelligence is a moving target. As soon as we are able to do something or complete a task that uses the underlying technology of AI, machine learning, natural language processing, we're not impressed anymore, and that's not AI. I myself, speaking from a legal research standpoint with Ross, one of my heroes in the space was Cornell's Lee Institute, just in terms of what they've done for freeing up data, et cetera. And just yesterday, they did a review of one of our free tools where they said it was fabulous, and they really got a lot out of it. And they also mentioned that our free tool, they preferred to some of the paid commercial feature sets from some of the larger entities in the space. Now, this isn't about self-promotion. What this is about, Hirsch, is to drive a point home. A small startup with very limited funding was able to use this technology to enable better access to legal information. And that is a direct result of machine learning and natural language processing. So I think if you're looking for, an AI robot that's going to go to court and do a whole bunch of things for you, it's not here, and it might never be here. But I think AI is something that can help bridge that divide, because it helps scale what was previously extremely expensive.
Great. Before we get to regulation, this is going to drive me to another point. I know you are very active on a number of university campuses, both in the States, in Canada, and overseas. Lots of people, I know we have a lot of young lawyers here. We have a lot of students who are about to become lawyers, and they probably hear this technology talk, and they probably hear this AI talk and say, what is the future for me? And I know you have some strong opinions about that. So is AI the end for lawyers?
No, absolutely not. What I would say is, in particular, when most of the time the folks in law school, regardless of their age, are very attuned to the fact that technology is going to help shape their practice, and they're looking forward to it. The most fear I generally see about this topic is generally from entrenched attorneys in the last 5, 10, 15, 20 years of their practice. And so what I would say is the future is extremely bright. Justice Himonas, I always love when he speaks, because he mentions the fact that he has a daughter in law school that he is paying a pretty penny for. And the fact that he wants her to have a really bright future, I think speaks volumes. And so I guess what I would say is, oftentimes the individuals who need help with figuring out how to use a word processor or upgrading from Internet Explorer 7 are the folks who are really worried about AI. And I don't think that really applies to most law students, regardless of the age they are. We're living in a very exciting time where we're now able to, a solo practitioner, a small law firm can have the impact of a large law firm, and harnessing that, especially with the regulatory reform on the horizon, is something that most students that I've spoken to from Canada, the United States, Europe, Asia, Africa, and everywhere in between are very excited about. Truthfully, Hirsch, I have yet to hear a law student, and I've spoken across the world, come up to me afterwards. Maybe there are out there and they just didn't come up to me, but most of them come up to me with great excitement in their eyes, because it's the difference between, when I was younger, teachers told me, Andrew, you're going to have to learn how to do math because you'll never carry around a calculator. And, I do know how to do fundamental math, Hirsch, but I do have a calculator. And what that meant in engineering is they went from a slide rule to being able to actually do a lot of advanced calculations, which is why we have some advanced technology. So I see that the legal field and legal precedent, the examination of it in the legal research world, for example, there will be a vast improvement. And I think when it comes to bias and other issues, I think that these tools can help challenge that. If you're able to ask a question, how has a Hispanic offender with such and such background been charged or sentenced by such and such judge as compared to an offender with this background or that background, and instantly get that data? You don't need 17 legal lawyers who are getting paid hundreds of dollars an hour to find that. I think that we can harness this technology on the horizon to have a very bright future, a lucrative future, and a future that's fair, because there's 80 to 90% of people out there with money in their pockets, with money in their bank accounts, who want legal services. Our regulatory framework and also our culture is what's preventing us from delivering those legal services. And we have a moral obligation to do so, but it's also a huge business opportunity.
Yeah, and obviously Ryerson just launching a new law school. We didn't do that because we thought there was no future. We did that because we thought we could arm them with different skills that other lawyers don't have and give them a leg up. So that's great to hear. Now you've mentioned the current state of legal regulation a number of times, and you have spoken a number of times about I think you call it re-regulation. So the current state of regulation, why is it holding people back from being able to offer more legal services in your mind? And what changes do you think can help open up and create better access to justice for lots of different people?
Well, I think you heard, and Crispin put it pretty well when he talked about the fact that what you're doing is you're giving the control of the, and actually Professor Hadfield mentioned it as well. I mean, it's been a theme throughout today, but when you hand over the reins of regulation to the folks who are delivering the services themselves, and that oversight, it's problematic in any field. And you don't want that in drug discovery, you don't want that, and you see some of that issues that happen in aviation. So I think what we're seeing is protectionism. And protectionism is really only helping the top 10 to 15 to 20% of our population. It's criminal. And so what I think that the biggest challenge to access to justice is our regulatory framework, because when you look at it, what it's saying is, if you're not a lawyer, you can't really truly benefit. Yes, you can be paid a wage, but even the way that they speak to non-lawyer participation in legal services delivery, the idea that by including or splitting fees with a so-called non-lawyer, that it's going to run amok of your ethical obligations, and that 3 years of law school somehow makes you more ethical than an individual who didn't go to law school. The true reality, and what makes it so insane, is that by someone who's done it myself, a lot of the ethic portion on the bar exam was just a bunch of videos that I know, and I have it on good authority, most folks skip through. So if that is what you're relying on as your evidence that individuals are somehow more ethically minded, it's a farce. And it's right now, I think the sheet is coming down over the Wizard of Oz that has been pulling the strings. And behind there, you're seeing aged, old, traditionally white men who have been calling shots for a long time and who want to remain the Wizard of Oz. But those times are done. And I think we're at a wonderful time in our history where we're questioning why things are being done the way they are. And we're asking, why aren't the benefit of a lot of services, which are fundamental human rights, why isn't that for everyone? To me, access to affordable, quality legal services is a fundamental human right, the same as it would be to drink clean water.
I don't think anyone can argue with that. Sticking to the re-regulation, deregulation conversation, a lot of times people point to ABS and investments and the ability to raise money can really make a difference when it comes to opening up the market and when it comes to increasing the access to justice. A lot of people don't live in the startup world and aren't looking to raise money often. Can you maybe explain or give your opinion as to why the ability to raise capital would help more people?
Absolutely. It seems complex, but it really comes down to the fact that in order to do anything, it costs money. And in order to start a company and to think through and ideate and be able to pay employees and pay experts in other fields, it's not something that you can totally bootstrap. Bootstrap is a term used in startups to mean when you're in a stage where you're not paying yourself and you're not paying others. And so outside capital is something that is essential because it also comes with outside expertise. You then are able to bring in individuals who were behind different ideas that shaped other spaces. And so that is a very pivotal it's one of the pillars that I mentioned earlier, which was that funding. But I also think the regulations and the rules also hinder what I had said, sweat equity, which was the ability to have individuals with different backgrounds and expertise, non-legal expertise. So you could have a lawyer team up with an MBA, team up with a social worker and deliver a new form of services within a specific segment of the market. And that is huge. I think that's very important. And we're in a situation where the idea that you have to be a lawyer to deliver legal services, you heard from Justice Timmer, she said, you don't have to be a doctor to own a hospital. And I think it's similar. And I do think that it's going to come down to a strong regulatory framework. There has to be, and I call it re-regulation, as you mentioned, Hirsch, because I'm not calling for a Wild West where there's no rules and whatever happens, it happens. I'm calling for different certification programs. I'm talking for specific limited license agreements where you heard from Crispin as well. Maybe an individual can only deliver this type of legal service or this type of legal service, because it really begs the question. This is odd, Hirsch. If you were a lawyer who practiced in a particular area of law in British Columbia for 25 years, and then you want to go over to Ontario to deliver that, and I have never delivered that specific area, but I'm called to the Ontario bar, and I can deliver it and you can't? Criminal. And the reason I'm using pretty strong language on purpose, because I think that history will show who's on which side of this. Because at this point, I think we're done with enough speaking about this subject. I think I'm very excited about what you're seeing in Utah and Arizona and what the change is coming. But I think every day where we don't have a regulatory re-regulation reform and some of these problems are fixed, it's just we're in a crisis. And we are calling for more conferences and more conversations about this. And so I'm delighted about the fact that today has been an emphasis on doing. You heard from Crispin what happened in England. You heard from Justice Himonas, it's happening in Utah. And I think, and Justice Timmer, what's happening in Arizona. It needs to happen in Ontario. It needs to happen in Canada. And every day it doesn't, we're leaving Canadians, Americans, and citizens of the world in a really horrendous situation.
So I think on that point, that is the perfect way to end for that call to action. And as we said, we're calling on Ontario to open the law and let the people decide. And so this was fantastic. And I think everyone sees, if they haven't seen you speak before, that this is why we are such massive fans of yours, Andrew. And we really, really appreciate all the time that you give us. Thank you.
I would just say, Ontario, you have to change. What are you scared of?
Thank you. Yeah, that's fantastic.
Take care, everyone.
It is 3:30, so we're just going to jump into our last session. So it is my honor now to really probably host the two top experts when it comes to access to justice. And again, very similar to what Andrew was saying, this isn't just talking about talking. They have 100% put in their actions behind their words. And so it's my honor to first welcome Julie MacFarlane, who is a professor of law and distinguished university professor at the University of Windsor. She has researched and written extensively on dispute resolution and in particular the role of the lawyers. Her books include The New Lawyer, How Clients Are Transforming the Practice of Law, and Islamic Divorce in North America, Choosing a Sharia Path in a Secular Society. She is currently the director of the National Self-Represented Litigants Research Project, which we have worked closely with during our creation of the Family Law Portal. And it followed her publication of the 2013 National SRL Study. Her current book is Going Public, A Survivor's Journey from Grief to Action for Between the Lines Press. Julie works on a range of social justice issues, including access to justice, Islamophobia, and justice for victims of sexual violence. She has a widely read blog and hosts a social podcast Jumping Off the Ivory Tower with Professor Julie Mack. And I believe her next book is From Grief to Action, Confronting Sexual Violence for Between the Lines. So it is a great honor that between all of that, she has time to join us here today.
Hirsch, could you unblock my video, please? Because I don't want everybody to be thinking that Mark is the best looking access to justice expert.
Let's see here. Yes.
And I'm already offended that you wanted Mark to, to be visible and me not. There's obviously something going on.
Julie, that had nothing to do with Hirsch. I always had control.
Yeah, right. In your dreams, buddy. Hi, Mark. Hi, Hirsch.
Hey, Julie. And Mark obviously is right here. Mark has been a lawyer since 1980 and has served as the CEO of the Legal Services Society in British Columbia since 2003. The LSS, for those that don't know, is BC's legal aid program and the largest public legal education provider. He serves as the Vice Chair of Canada's Action Committee on Access to Civil and Family Justice. He has had a central role in the collaboration of government and non-government organizations since 2008, including chairing the Access to Legal Services Working Group. Mark's legal experience includes general practice, appellate advocacy in the BC Court of Appeal and Supreme Court of Canada, and 4 years and as a adjunct professor at the University of British Columbia Faculty of Law. He's a past chair of the Association of Legal Aid Plans of Canada and contributes to a number of Canada's government and non-government justice task force and is the founding member of the Access to Justice BC. I can go on and on with both of these people. Absolute experts. It's a great honor to have them, and both are very good friends of the Legal Innovation Zone. So thank you very much. I will hand it off to the two of you.
Thanks, Hirsch.
Thanks very much, Hirsch. And hello, everybody. So Mark and I, who, don't agree on anything, we put together a series of questions that we thought we would each take a go at answering, I'm sorry. So I'm going to get us started. Mark, what difference does the pandemic make to access to justice?
Julie, it's something that I think is one of the big questions many of us are talking about, including you and I, as we have the opportunity. And I think we're seeing a couple of things from my perspective. One is that really rampant collaboration is breaking out in a number of different places that leads to things like Andy talked about earlier. We're suddenly allowed to use digital signatures or suddenly allowed to send emails to court registries, right? Things that, there's lots of reasons to shake our heads about why they didn't change sooner, but some good news here. Lots of collaboration going on. And while I wish there was more and more coming out of it, we do work in a system that does value continuous learning, and I'm hopeful that there'll be some lessons learned that come out of this that aren't entirely cautionary tales, right? But rather how to do this work better. I'm just going to go on for just a minute because there's a couple of examples I want to give. But partly this feeds into the what should younger lawyers do issue. Earlier this week, the Canadian Bar Association came out with an access to justice document, part of which focused on lawyers taking individual action around access to justice. And while that's not a novel idea, actually it being promoted at that level where it's about a question of personal and professional responsibility to engage is an interesting development that I think fits in part in the COVID environment. I'm seeing things also out of the Law Society BC, of which I'm a member, where their futures work is looking more at some of the issues that we've been talking about today. Now, they haven't acted on them, and as we all know, lawyers are terrific at talking and writing about the way things should be or might be. And it's not that I'm holding my breath waiting for action on that, but I'm really quite optimistic. And in part, that's happening because there's a bit of a generational change happening in justice right now that it is noticeable. And I really see it when in some of my networks that are more international, headed up by the OECD and others, where, Julie, everybody's younger than us.
Oh, but no, you mean younger than you, Mark, not younger.
Well, I would say even younger than us. Perhaps that's a better way to put it.
Okay. Well,
What are you seeing? What are you seeing, Julie?
Well, interestingly, usually I'm the glass half full girl. I'm kind of famous for my perpetual optimism, even in the face of, chronic paralysis when it comes to change in the legal profession and in legal education, which is basically the story of my last 40 years of work. Paralysis and very little change. But you actually sound a bit more upbeat than I do about the impact of the pandemic, Mark. And I can certainly see, as we talk about in the next question, a few silver linings. But what it's really brought home to me sitting from the perspective of the self-represented litigant population is we're seeing even more attempts to try to separate out self-represented litigants as a disadvantaged class. I mean, just a class within the legal system. So, for example, as the courts were closing down and setting rules for who could come on what kinds of matters, we saw a blizzard of what the courts always call notices to the profession. Been a couple of exceptions. Every now and again, that word public comes in, but generally we're talking about notice of profession. And the next problem was, of course, that they were written in such complete legal gobbledygook that even members of the profession couldn't understand them, certainly not members of the public. And NSRLP has spent an awful lot of time in the last 6 months trying to translate them. But we've also seen other things. We've seen introduction of e-filing that's available in particular courts, but not to self-represented litigants. I mean, this has been done explicitly. We've seen, the reintroduction of judicial dispute resolution JDRs, but not if you don't have a lawyer. We've seen the reintroduction of non-urgent cases, hearings, but again, only if you have a lawyer. And, we've also seen, obviously, this kind of total translation of everything that goes on into the virtual world. So now we see virtual hearings. And although, and I'll say in a moment, I think there are some definite advantages to virtual hearings for people who aren't represented and who are basically taking time off work to attend court. We also know that they are problematic in many ways. The Nuffield Foundation just came out with a study this week from its Family Justice Lab that said that 40% of family litigants said they either barely or not at all understood what was going on in their virtual hearing. I mean, that's pretty shocking. And I'm not sure that that's going to be that different across the pond. So, I see some significant problems here, and I am happy to talk about silver linings in a moment, but those are the things that I see as really problematic.
Well, and I think as much by force of habit, I wanted to start with the start of the part of the sandwich that might be a little bit more upbeat, but let me go into what are some real concerns that I have right now. And these are concerns of mine, not necessarily of Legal Aid BC or the Action Committee or any of the other groups that I serve. But when I'm looking at what's going on or talking to my colleagues in other legal aid plans, we are clearly seeing people at the margins being pushed into invisibility, right? That very problem that you've articulated. Yeah. Now, there is some attention being paid to this, but I think not remotely enough. The courts are deeply important in our structure of our society and in the social cohesion that holds us together, as is generally the access to justice issue. And I should say, because Andy raised this earlier, that by that I mean people having access to the information and advice they need to resolve their legal problems, right? That broad definition is what I'm talking about. I'm not just talking about access to courts.
No. You and me both, Mark.
I just wanted to, I know that you knew that. I
meant
that.
No, but let's make it clear.
For the audience purposes. I do think that what we're going to need to do, because I think digital hearings are here to stay, is fairly radically rethink how it works. I haven't seen the Nuffield Foundation report yet, but my own organization did a mid-pandemic, I'm hoping it was mid-pandemic, it was done in July.
We'll see.
Legal needs study. We do one every 5 years typically. Really, we saw problems have increased materially, the incidence of problems, the number of problems the pool experienced increased, about more than a third of the problems were influenced by the pandemic, either caused by or made worse by, and resolving them was more difficult in that environment. So all the things we know
Right.
about access to justice, all the indicators just got worse.
Right, right.
All of them.
And
Go ahead.
oh, I was just going to say, and the other side, just as you started to say, Mark, of all of this, now we're working in a digital environment. There is much more. All of a sudden, all the courts who said they couldn't possibly do this have introduced e-filing, and all of a sudden, the courts who said no, they couldn't accommodate self-represented litigants who didn't have childcare, or people with disabilities who couldn't travel to the courthouse and couldn't offer them a virtual hearing, which people have been asking for years. All of a sudden, they can do it now. So, I guess that's a good side. And I mean, we certainly see, and I think it's going to be especially interesting to see how this one works out. We are seeing in the use of virtual technology, digital technology, we are seeing just a little bit of power being taken away from where it usually is. So now we have virtual witnessing of affidavits and wills and powers of attorney and so forth. And in some provinces, there are emergency regulations that allow for holograph wills, the kind of thing that was permitted previously during, the world wars. And I have a very strong feeling, and you're already seeing this in BC actually, that rolling back those changes to require people to yet again go to a lawyer's office, pay for them to spend the time to do the witnessing. I think it's going to be very hard to roll some of that back. So if we're looking for some silver linings, I think that's one. And one more thing I want to say on the silver lining front is this, that since we started NSRLP in 2013, we have been saying to the legal system, to judges, to lawyers, to anybody who wants to listen, we can give you user feedback. We are growing a database of people who have experienced the system as self-represented litigants. Many of them are extremely highly educated. They are very articulate. They have lots they can tell you about their experiences. And Mark, you've shared in this with us when you've come to the dialogue events at the University of Windsor. But we got very little take up on this. I mean, I would say my summary would be, for 150 years, the justice system wasn't interested in listening to its users. And all of a sudden, there is a pandemic and NSRLP is now underwater with organizations, tribunals, courts, and we are delighted, who want to talk to users. And I think that has somehow come out of this, that it's caused that kind of triggering of a whole rethink. And inevitably, if you're going to rethink a 21st century service, you have to talk to the users. Duh. So a little sign that I'm very fond of from the office, it says, public voices matter. And we have been kind of bleating pathetically in the wilderness about this for a long time. But one thing that has happened in the pandemic, I think, is now people do want to hear from those users. And we are very happy to help. We have a database of more than 1,000 people that we can sort according to all kinds of variables and provide you with user input. Any more you want to say about this,
Julie,
Mark?
I have to say, having spoken with you routinely over the last 6 years or so, I have to admit, I haven't seen you so pleased with change.
Yeah, I'm pretty pleased. I mean, yeah, we have a lot of requests now, and we're very happy about that.
So as you look at that trajectory, what do you see happening next on it?
With the usage trajectory, the input from users?
Yeah.
Well, it is really interesting. I mean, we're kind of chipping away here. One of the things that we have just succeeded in doing is persuading one of the tribunals that we're working with on user input to give an honorarium to the people who are going to give their input, which, ought to be a matter of fact in any kind of user input. But because the great unwashed public were not people whose opinions were being sought for such a long time, it takes a little bit to get over actually paying them something for their time, which of course is nothing like as important or valuable as the time of a lawyer. So hopefully we've overcome that. I think I would really like it to be the case that it is a regular, and I know in BC actually, there is an effort to do this in the Justice Ministry, and we're working with them on this. This should be a regular thing that happens in every court and tribunal every year, just like your legal needs study, Mark, that's 5 years. I think user input should be more regular. And I think it should be something that people don't think twice about, that of course you need to know if an innovation is being successful, if it's being used properly in the way that it was imagined, what all the unintended consequences are. I mean, I'm going to get nerdy empirical researcher in a minute, so don't let me go there. But there's so much to find out.
I will do my best to stop you. I haven't always been successful at that, as I know you know.
Yeah, but I just like to see it as an accepted fact, and and in exactly the same way, I'd like to see that permeate the culture of private law firms, that they ask their consumers whether or not they're doing a good job. I mean, there are some law firms who do ask for feedback from their clients, but they are a very small fraction, and I'd like to see that as being completely normative, that you always ask for user feedback.
I think, Julie, just while we're staying on this appreciative note, there's a couple of other things that are happening in the system. I'd mentioned the BC Law Society. I'm seeing some other institutional change that is kind of opening up the justice system itself to broader and more collaborative discussion that's happening partly because we're doing it all online. And I think in some ways it's easier to organize.
Yeah.
And easier to share views. And what I think one of the things I find most heartening right now is some of the international agencies like the OECD and the World Bank, who are basically economists, which means they have a more systemic analysis that they bring to bear. Are looking at justice and the value of justice and seeing access to justice as a key piece to GDP. In fact, I was listening to somebody last week who was talking about better access to justice can confidently lead to 3% increase in GDP over 10 years. That kind of broad, long-term conversation. I think it comes back to the importance of the conversation that you and I have been listening to all morning or into the afternoon, because it's still, not late in the afternoon here in BC. There's key elements to how we have access and how we provide assistance and how it works that aren't serving us well and need to be assessed and changed. And so I think too that there's a number of issues that are coming together where the pandemic will help set the foundation, not a full catalyst for the change, but help support the change moving forward, as you've commented on already.
Yeah, I think just setting it's a climate of change. It's a time of change. And I hope that we can continue to see more good things from that. So, but I want us to make sure we have time to talk about these two next couple of questions, Mark. And we're now going a little darker, okay? So you can play the do-do-do-do kind of music here in the background. We decided that we would talk about what most worries or scares, I think scares was my word, you about the current state of access to justice in Canada. So, pandemic aside, silver linings aside, do you want to talk about what worries you the most?
Yeah, for me, it's people at the margins being pushed into invisibility. I'm deeply concerned about that. I saw again this week a comment coming out of the current action committee chaired by the Minister of Justice and the Chief Justice of Canada, where a committee explicitly commented on this issue that digital is not going to work for everybody, and we need to be aware and address that squarely and fund the solutions. So I'm pleased that there's an acknowledgement of the issue that's surfacing now. I didn't see much about that before last week, apart from my own circles. We do know already from the work that we do at Legal Aid BC that our clients don't like using public libraries to do a court hearing. Right. And it's completely understandable. Who would want to have to sit in a public library because it's your only accessible internet point. So that's my big one. That has lots of implications. That's about not paying attention to the people
Right.
who actually are entitled to use the service and use it. And again, it relates to much of the conversation we had today. It's about how we design the system in response to COVID and making sure that, as you've already commented, the voices are heard. I'm pleased, really pleased to hear that tribunals and courts have been in touch with your organization. Because what I hear from the delivery side is that tribunals just as important for tribunals to be attended to this issue as it is for courts, and perhaps more, particularly for those who deal with a really pointed end of the stick of legal problems like housing and income.
And immigration issues and so forth. And, you know, we saw in the original 2013 report, although there was that was focused on court users, the work that I did, there was a 10% sample from tribunals. And the interesting thing, and, you know, and I think that the tribunal, you know, tribunal members and proponents were maybe a little miffed by this initially, was that there seemed to be no difference in the misery and wretchedness of the experience of self-represented litigants in tribunals than there was in courts. So there are very similar issues of accessibility there. And we are absolutely thrilled to be working with the tribunals that we're working with now on how to be more self-rep friendly. But to go to my
I you know, I didn't see this so much as the darkness question. Maybe just the time of year is the Halloween question. So what's your scary issue right now as you look at
I mean, I'm going to go a little darker here. I mean, I find it very odd that I'm being the dark, pessimistic person here, but you know, hey, when we talked about this question, Mark, and I said that I wanted to use the word scared, this reflects the fact that I am constantly, you know, in touch with, hearing from, talking with people who are trying to access the courts without a lawyer, the courts and the tribunals. And, you know, I always say as a Brit that Canadians are remarkably good at being polite and courteous and not getting mad. But, you know, there are a lot of really, really mad people out there. When I say mad, I don't mean that they're mentally ill, as we have, you know, formally labeled all self-represented litigants. I mean that they're angry, and they're angry because they thought that they lived in a country in which they could access justice. And I can't tell you how many hundreds and hundreds of times I've heard this story. But then they went to court without a lawyer because they'd either run out of money, they'd had a lawyer originally, and we know 50% plus of self-reps are in that group, or they'd never had a lawyer because they couldn't afford $350 an hour. And they find that they're not really able to access justice. They find that they are treated differently in the courts by judges, by others than lawyers are. They feel they don't get a fair kick at the can. And what they end up telling me is that they have lost faith in the institutions of justice in this country. And it goes actually even further than that. I also hear a lot from people who believe they have a legitimate complaint as a result of their experience in the legal system, either a complaint against a lawyer or a complaint against a judge. And I want to say a little bit more about this in a minute, but the complaint system of the Canadian Judicial Council and the complaint system of the Law Society of Ontario, which is the one that I know the best, but I suspect is not very different from others, are completely broken. And I constantly advise members of the public who want to make complaints about judges or lawyers not to, because I know what's going to happen. I mean, we have the data to show it. They're going to spend a lot of time making a complaint. They're going to wait anxiously for months to hear, and then they're going to be told, no, sorry, your complaint doesn't fit our parameters, and, you know, it can't go forward. So this failing faith in being able to go to the courts and access justice, and then if you feel that you were not treated properly, complain about that. In other words, hold those institutions accountable. It is a catastrophe at this point. And I don't think I'm being hyperbolic here. I'm not suggesting that we're about to see a pitchfork revolution, but sometimes I lie awake in bed at night and think something really, really, really bad could happen soon in a courthouse or courthouses. And I don't think that people who work in the justice system necessarily really understand just how bad this failing faith is out there. And I'm not just talking about, working class people or poor people who can't afford lawyers. I'm talking about professional classes who do not find the same accountability in the legal system as they have to face within their own professional structures. So that's my boom.
It's a pretty big one. Thanks.
Yeah, it is pretty big.
Julie, as you were saying that, one of the things we've been asking in that survey that we do every few years is about confidence in the justice system and how good it is at resolving problems. The numbers have been fairly stable. And as a colleague of mine, as a former chief judge of a province that will go unnamed, has pointed out to me that the 49% who believe the Canadian justice system is essentially fair is slightly less than the number of people who believe aliens have visited Canada sometime in its history, geological history. Is the way that I think that's a Huffington Post number, the latter, the former is from the survey. And look, there's lots of reasons to be skeptical about that, to be skeptical about how the system works, and clearly a lot of room for improvement. And I think that as we're looking at how do we ensure that services are available to people, sort of the thrust of much of the conversation today, it's clearly part of the problem, right? The more historic institutional levels of doing that. What do you want to talk about next?
If you could change one thing, and it's just been reiterated here by the secretary who put the notes together for us. That's another conversation. If you could change one thing, just one thing about the current system, what would it be? You go first.
Well, one of the things that came out of the Action Committee on Civil and Family Justice, Access Justice and Civil and Family Matters, was really focusing more on outcomes that people experience, seeing the legal problem in its social context and addressing it more effectively. That's what I would love to see. That would drive quite a bit of difference in the organization of justice system institutions, from how we measure what success is to how we provide the supply of people who assist with the problems, to when we intervene and how we intervene in order to help people. And it's not just to help people, it's to empower them to solve the problems. How our institutions work, and how they respond. It's really a view that's quite deeply different than how we treat justice or how we are taught law.
So when you say focusing on changing the outcomes, what do you mean? What would that look like, Mark? Well,
here's one. The surveys like the one I was just talking about, which are not new or particularly innovative. They've, as you know, have been going on for 30 years or so. Really quite a consistent response from people, right? When they have a legal problem, what they want is to not have the legal problem. That's what they want. And they want processes to get there that are reasonably easy to use, reasonably inexpensive, timely, and here's the things we're good at: authoritative, transparent, and fair. We're really good at authoritative, transparent, and fair.
Yeah. Well, we're really good at the authoritative part. I'm not sure about the other bits.
No, and it's interesting, as we started the day with a short talk about World Justice Project, as many people in the call will know, Canada's sitting about 9 or 10 in the current rankings, but we don't do remotely as well on a couple of those issues like timeliness and cost, right? We're down in the 40th and 50th, or on discrimination in relation to how the justice system works. And all those things are key elements for how people experience the system, how users experience the system. right? And I'm
Yeah.
not painting with a big broad brush. I think the World Justice Project report speaks for itself and the
Yeah.
rankings that it uses, and we can argue about the methodology, but it's at least an indicator of things that we ought to be paying attention to. So,
And the things we're
as
not
I
doing well.
look at,
Yeah. Yeah.
as I look
Well,
at
I
those
think you
outcomes,
cheated. I think you cheated in your answer, because your answer, is like everything. It says one thing, okay? And you've said we have to change everything, which I agree with. So let me have a go at my one thing, okay?
yes, go for it.
But I'm going to
And
cheat.
you know that I'll be paying close attention to how
Oh,
you
I
choose to
know,
frame
I know, because I'm going to cheat. I'm going to like build up to my one thing. And I would be actually terribly curious to know how many of the people who are at the conference already know what my one thing is. So here's the thing. I call it the dirty little secret. The dirty little secret of access to justice, and what came out very clearly from the research that I did in 2011 to 2013, and has since been reinforced by our ongoing intake data, which we analyze every year, asking people who are self-represented about their experience. Here's the dirty little secret. The thing that people are asking for help with overwhelmingly is procedure. These crazy, arcane, inexplicably complex procedures that we, the legal establishment, have created. The number of people, or the amount of help that is being asked for in relation to substantive law, in other words, the kind of stuff that lawyers do, is way, way smaller. Now, that doesn't mean that everybody who's a self-represented litigant understands the law as well as the lawyer, obviously. And I think there might be some who think they understand the law better than they actually do. But it's so important that the perception here is overwhelmingly, I mean, there's no competition, that what they need help with is procedure, not substance. For substance, they can go on CanLII, they'll make a stab at it. What trips them up all the time is procedure. And here's the thing, as you know, Mark, you don't need to be a lawyer to give somebody information about legal procedure. Now, I know that law societies try to make people feel like they have to be. This is why one of the people I interviewed once in a court registry, who I asked about this, and I asked, what do you do if somebody forgets to sign the form? You could tell them they've forgotten to sign the form. That's not legal advice, but all of these folks are so completely paranoid that they're being watched and, they will be imprisoned if they give legal advice, that she said what she did was she took a sticky note and she stuck it on the piece of paper where they'd forgotten to sign and would go without saying anything. Now, this is not a good way to run a 21st century justice system, can I point out? It's completely ridiculous. So if people need procedural help, and if you don't need to be a lawyer, and I'm sorry, but you don't, to give legal information because that's legal information, not legal advice, then what we need is diversification of legal assistance to enable people to get help from all kinds of different individuals who have skills that they need in order to be able to navigate the system. They need editors. They need people who will read their drafts. They need people who understand the procedure and the forms, people who are really familiar with these wretched, arcane forms. They need people to rehearse them before they go to a hearing and have to speak to the court, which is the thing that self-reps are always the most anxious and intimidated about. So we know we need the diversification of legal assistance, and that is directly related to what people are asking for. The law societies in this country have consistently and continue to block the diversification of legal assistance and have continued to try to assert control over all of these areas, whether they be, advice giving or whether they be information giving. And we've seen that in British Columbia. We've seen it in Ontario, although hopefully it will change shortly in Ontario in relation to family paralegals, but we'll have to wait and see. But, there's not a good record on this amongst the law societies. They have stood in the way of change. There isn't either a good record on the way the law societies handle their complaint systems. Again, as I mentioned earlier, the one that I'm the most familiar with is in Ontario, where I know from the data that we have gathered that only 1 in every 5 public complaints actually makes it through to a hearing. There are also differences in the way that the professional codes, and I think a lot of people don't know this, there are differences in the way the professional codes are interpreted and applied, whether that be to other lawyers who appear to have broken them, or whether they are, whether that application is being made by another lawyer or another lawyer's client, or whether it's being made by a member of the public who's not a lawyer. And I have personally experienced this myself. So there are certain provisions of the code in relation to honesty and integrity, which I have been flat told do not apply as a duty to a member of the public. They only apply as a duty to another member of the profession. Now, I mean, this is BS, frankly, you know, and I just want to call it for what it is. It is absolute BS. I've been asking the Law Society of Ontario, and they are my good friends, for at least 2 years now to tell me what are the differences in the way the rules apply if you apply and make a complaint as a member of the public as opposed to another lawyer's client or a lawyer, and they won't tell me. When I went to law school, we were told that the reason that there had to be self-regulation of the profession was because they were the best people to regulate themselves and to hold one another accountable. I didn't listen a lot in law school, but that part I remember. That was drilled into us. And so I say, it's done. Another sign. This says D/re, thinking of Crispin and being very aware of what's happened in my homeland, re-regulation now. It's time. That is the one thing I would change. And I know that this, you know, is going to take me off a lot of people's Christmas card lists, but honestly, it's enough already. Unless the law societies can really get behind understanding that people want procedural assistance and they don't have to control all of that. They don't have to stop people getting that assistance, and they need a proper complaints mechanism that treats members of the public in the same way as lawyers. We need to change.
Julie, we got like 4 minutes left.
Go for
Chris,
it.
do we have 4? Do we have 4? We've got 4. Our last question here is about why isn't justice change happening? This is probably the most common conversation I end up in, and we're not going to do much justice for it, but I want to start with a Mark Twain quote. Everyone likes progress. Nobody likes change. I think that's one reason. I think another one is that systems thinking in the justice system is rare. It's why bringing in the economists to have a look at how it's really working for people, I think is the chance to be transformational in how justice systems are looking at this. The justice system is a system with interdependent, interrelated parts. It is not an organization, so there's no single person accountable for how it works. Attorneys general do not have that accountability overall, though it's interesting about whether they should. I think when I look at the skills among my colleagues, planning and execution of change are not in their resumes. Right? They just tend not to have much chance to do that. And after all, we do want a justice system that's predictable and certain and reasonably stable. So there's a bunch of reasons for all those things. I do think, I was asked some years ago by an outgoing politician about whether I thought there should be a separate ministry for justice change, which I thought was an interesting idea that I haven't heard before or since. But I think given much of the conversation we've had today about the importance of ensuring an outside oversight and direction, coordination around issues, I think that might have been a pretty good suggestion that perhaps should be revived. Julie, I'm going to give you the last word.
There is a fundamental disconnect. And, you know, I could see this 40 years ago when I first started teaching law. There's a fundamental disconnect between what we're training people to do as lawyers and what people actually need and want. And 40 years ago, I didn't know the details, but I just could see the disconnect. I have spent 40 years looking at the disconnect. We're still unfortunately training people in the same way. To be a traditional lawyer means to be detached, provide a technical objective view, to be in charge, very important, to be in control, to tell the client what to do. And then we turn that into, oh, and I have instructions too, which I always think is totally hilarious. When somebody says, I have instructions, it means I've told my client this is what they want generally. And until we can get to the point that we recognize that the 21st century consumer wants a different kind of help, that they see themselves as far more empowered in decision making, and they would like to be able to afford assistance, and the rest they'll do themselves, I don't really have a lot of hope for the kind of cultural change that we really need. And, you know, I think the legal profession, sadly, is a long way behind other professions in recognizing what people really need and really want. So I think that is a really important reason that change isn't happening. And because people are committed to that old model, that was the model they were trained in. That's the model that's nice and warm and cozy and comfortable. And anything that's different, even the slightest little tweak, like allowing people who are already acting in this role as legal assistants to be called paralegals, they're already doing this, the slightest tweak feels challenging to that, because it's essentially a model that is an unchanging model. I mean, part of, and this is what you said, Mark, there is a need for that kind of constancy in the justice system, but there is not the same need for constancy in the way that services are provided, because they have changed and the consumers have changed, and we have to move with it. And I'll stop talking.
Well, I'd like the both of you to talk for hours more. I really want to thank you, Julie, you, Mark, for your insights. I want to thank you for speaking for those who wouldn't be heard from without your voices, not just today, but throughout your careers, for reminding us that there are many different people and issues out there. There are a lot of people who get missed. They don't have the voice, they don't have the ability, they don't have the resources, they don't know the roots. And but for the work of the two of you, they wouldn't get some measure of justice. Your advice to us was very, very powerful, very good. I love the fact that you agreed on every principle, might have disagreed a little bit or shaded the details a little bit of each other, but always a very energizing conversation. Thank you so much. Thank you for your great work.
You're very welcome.
And that brings to an end the conference. The first thing I want to say is thanks to my co-host and co-founder, Hirsch Perlis, for his work in organizing this, his work in co-hosting this and directing so much of the conversation. I want to thank the team at the Legal Innovation Zone for the work they did behind the scenes in making this happen, everything from publicity to suggestions to direction. It just doesn't happen with a lot of people behind the scenes, without a lot of people behind the scenes. I want to thank all of you for joining us. I want to thank our speakers, Mark and Julie, just finished, Andrew Arruda, Justice Timmer, Justice Himonas, Crispin Passmore, and Gillian Hadfield. Really want to thank you for your insights, your time, your dedication to the cause of advancing justice. You know, it's not easy to advocate for change in a profession that's not always been open to it. It's not easy to lead change, as all of you are, in a profession which doesn't always see the value in it, doesn't often see the value in it. And I want to leave with this. Whether change happens quickly or not, change has to happen. It has to happen for people and businesses, the overwhelming majority of whom are not being served by the existing approach. You can talk about the details, you can talk about different groups, you can talk about all the effort that's being made. The fact of the matter is that the facts are clear. People aren't being served by the approach. And it's their right to justice. It's their right. It is In the interests of regulators to make sure they have a regulatory scheme that actually serves the majority of the public. I can leave it at that. And I would ask of the regulator one specific change. No, I'm not expecting that the monopoly entity is going to jump up and say, end my monopoly. That is not likely to happen. But there is one rule restriction you could change tomorrow, which has absolutely no evidentiary basis. And that is the restriction on non-lawyer participation through equity in a legal services business. There's no evidence for that. There's never been evidence for that. As a profession of those who believe in evidence, we should make rules that are based in evidence. The pandemic has reminded us of the importance of evidence-based decision-making. Should be made that way in law. To members of the bar, change is tough. Crispin made the point that change is happening, whether we like it or not. Change has been happening for a while, but two factors are really driving the acceleration of change, and that was happening long before the pandemic. One is that we're in the age of the consumer. In every other area of life, we've left the age of the producer and we're in the age of the consumer. Consumers who want their services 24/7 in the way they want it, at the price they want it. The law is coming very late to that realization. And we're in a global world driven by technological change, and that is accelerating the power of the consumer. Law as a profession has rejected so much of technology, has held it at bay for so long. We are a long way behind other areas. Consumers will get what they want. If you want to be part of it, you need to embrace it. Consumers have been clear what they want out of law and the legal system for a long period of time. It's not a mystery. They want a simple, fast, affordable approach to understanding and resolving their legal issues. At no point do we seem to have been dedicated to that. We could do that in the courts, quite simply. We could do it outside of the courts and tribunals. We could do it in the approach to information. We could do it almost anywhere. We just haven't yet done it. There's an opportunity there that could be realized beginning today. To members of the bar who have not been invested for as long in the way things always have been, I would say this. And I say this as somebody who runs a lawyer licensing system for the Law Society of Ontario. I believe in your abilities. I believe you are going to make the change you dream of. The change that you wanted to go into law for. I believe that you have developed a series of skills, abilities, knowledge far beyond what you've learned in law school or during your legal journey. You know you can work in groups, not just individually. You can work with people who aren't lawyers just as easily as with lawyers from all different backgrounds and all different walks of life to focus on tasks and to get them done and to make change. You've grown up in an era of rapidly changing technology and you use it in every other part of your life. We need you. We need you and we need the change you can bring. But we also need you to be able to use all of your skills and abilities, not those restricted by artificial barriers or the myths of a time gone by. So when a more senior member of the profession or a legal leader says, you can't do it that way, you should ask why. What's the evidence for that? What's the reason for that? Why do we restrict my right, your right, to build your future? You need to be able to build and live your future and not just live somebody else's past. Freedom is a powerful thing, but in a democracy, freedom is a lot of what we value. You need your freedom back. You need your freedom to build your future. And we need the future that you're going to build. There's a lot that we can celebrate in justice, but gosh, there's a lot that needs improving. And you are on the front lines of this. Which brings me to the ask we outlined at the beginning, the ask of a government. No, it's not an ask for more money or more judges or more lawyers or more stuff. It is this. Then the 8 out of 10 people who aren't getting the justice they have a right to, well, they're your neighbors, they're your constituents. They're women and men and children. They're people with employment issues, with contract issues, with household issues, with rental issues. They're women suffering domestic violence who need to get out of relationships. They're families that need to get separated. They're people with contracts to enforce. They are your voters. When you pass a law to protect them, the justice crisis means that 8 out of 10 of them are probably not going to get the benefit of the law you've passed to protect them. Businesses, 9 out of 10 of those businesses are not getting the legal help they need on important contract, HR, expansion, contraction issues. The pandemic means that so many more businesses are going to be at risk. Which one are you going to say yes to? And which 9 are you going to say no to? For the businesses on the streets in every single one of your ridings. You know, the single most important move the government of Ontario can make in advancing justice for Ontarians and businesses is to give people choice. Trust people. Give them the right to find some measure of justice where now they have none. Do for those seeking justice what you've done during the pandemic. Open it up. Allow different voices, allow entrepreneurs, those with different skills, to help with the crisis. And the crisis in justice is long-standing, far predating the pandemic. This is an opportunity you have. Premier Ford, you did not create the justice crisis. It's been around for many decades. But you can take the single most important step in advancing it since the creation of legal aid, in advancing access to justice for all Ontarians and businesses, in advancing justice delivery for Ontarians and businesses, simply by opening the law, ending the monopoly, letting the people decide, and as part of that, letting lawyers compete with all of their skills. Oh, and one further thing. It won't cost you $1. Thank you all for your attention. On November 26th, we have our next conference, Justice for All, building for the 80% the system leaves out. Thanks for watching. Take care. Bye.